All right, we're back on record on State versus Krager. Remind everybody to turn off your cell phones or other electronic devices. All right, now ladies and gentlemen, jury service may be strange to some of you, so a short explanation is in order. Those who participate in a trial must do so in accordance with established rules. That's true of the witnesses, the lawyers, the judge, as well as jurors. Lawyers present the evidence according to the rules. The judge enforces those rules and determines what evidence may be submitted. Now, as jurors, you will be the sole judges of the facts, credibility of witnesses, and weight to be given to their testimony. And at the conclusion of the evidence, I'll give you the instructions on that, the legal instructions on that. And you'll apply that law to determining the facts. It's your sworn duty to accept the law as it's given to you by the court. Now, the procedure for the trial will be as follows. First, the attorneys are going to make opening statements. These are not evidence. They are simply their preview, if you will, of what they believe the evidence will be. And they are designed to help you follow the evidence as it is presented. But they are not themselves evidence. Now, after that concludes, the state will offer its evidence. And then upon completion of the state's evidence, the defendant may, but it's not required, to offer evidence. If the defendant does offer evidence, the state may, but is not required to present rebuttal evidence. And then after that, the court will instruct you on the substantive issues on the charges, the law regarding that. And then after closing arguments of the attorneys, you'll be instructed on how to deliberate and return verdicts. Now, witnesses will be questioned as follows. The party that calls a witness will ask questions first. It's called direct examination. Once that's completed, the opposing party may ask questions. That's called cross-examination or cross. And then after cross-examination, the party that called the witness may ask additional questions about what was brought up at the cross only. That's called redirect examination. Now, jurors are not permitted to ask questions. During the trial, it's likely attorneys will make objections. That's the procedure by which a legal issue is brought to the court's attention that needs to be decided. And I determine that based upon the rules of evidence and the law, because I'm subject to that too. I just don't say, well, I think this is what it ought to be or it's fair. I have to apply the law to those objections. If I say that the objection is sustained, that means the question and or the answer are not permitted. If I say overruled, then I've determined that under the law both are permitted. Now, occasionally, people, actually not occasionally, almost every case I've ever had, when people are being questioned on a witness stand, there'll be objection made before the witness is done answering, or while the witness is answering, or the witness may answer before the objection is made. And then once the court decides it, if I decide that it was not proper, then that is testimony that will be disregarded or stricken. And what that means is that you can't consider it. Now, we know you're not computers where you can hit delete and it's just gone. But what it means is that in deliberations, if somebody says, well, this was said on this one matter, but if it was deleted, if it was overruled or was sustained and stricken, that means you can't consider it. You may remember it, but you're not permitted to consider it. Now, it's important that you be fair and attentive. As we indicated, this is going to be a really long trial. It'll be fairly short, but you need to pay attention and listen to everything as it comes in. I don't permit note-taking on short trials because I think that people might tend to not, at the beginning, I know my own experience as a freshman at Ohio State many years ago, when in my first class or two, I started writing down everything that was being said and realized after I looked at my notes, a lot of what I wrote down really wasn't, it was just kind of preliminary, didn't mean that much. And then I got to thinking, I wonder how much I missed when I was writing it down, because back then I couldn't write and listen at the same time. I've learned that skill, at least I think I have, but over the years, because it's just a job requirement. But it can be distracting, so I don't allow notes on short trials. Now, it's important that you not discuss this matter during any breaks with anyone. You're not permitted to allow anyone to discuss it with you. You're not to communicate about the matter during the breaks. So if you're on social media and you post, you don't post about this. If you want to say you're on jury duty, fine, but don't say anything more than that. Even that's kind of dangerous, because what that might just prompt somebody to post something back that says, oh, I bet you're on that one trial. And so then you might end up hearing something you should, because they don't know the rules. They're not here. You are. So it's just best not to say anything. So if you want to post on social media, post about anything other than the case. And the reason for you not to discuss it among yourselves, you can't permit, and that's kind of a little more difficult to understand, because we're going to be taking the lunch break and maybe other breaks during the trial. And the reason for that is that until you've heard all of the evidence, all the instructions of the law, the opening statements, closing arguments, you haven't heard everything. The case has to be decided on the entire trial, not just portions of it. So it would be improper to discuss it and start forming opinions or about it until before that occurred. And it's also important that in deliberations, it has to be among all 12 jurors. And so if some of you are having lunch together or standing outside during the break, if you were to talk about it, that's not proper, because you don't have all 12 of you deliberating. And you'll need to explain this rule to anybody you might be in contact with during breaks, because they, again, are not here, don't have that instruction. Once your verdicts are reached, the case is concluded, then at that time you'll be permitted to discuss the case if you choose. It's your choice. You don't have to, but it'll be up to you to make that decision. You're not to investigate or obtain any additional information on this case outside of the courtroom. It's highly improper for you to do that. And as mentioned earlier in the voir dire, that doesn't mean just going out, say, driving over to the scene or something like that. It also means don't look up anything on the internet. If you hear something about a topic that you say, well, that's interesting, I'd like to know more about it, or I'm not quite sure that's right, I'm going to check for myself, that's the same thing as getting information, and that is getting information outside of the record, and it's not proper. And as I've already alluded to, you're not to read, view, or listen to anything that might be on a newspaper. We might get a posting on their websites or social media accounts, but don't read those. Don't permit anyone to read or comment about them in your presence. Don't listen to anything on the radio. If we should make radio, we don't really anymore, because we don't have local news anymore. Or to view anything on TV, and again, I doubt that that'll happen either. But if it should, you're not to view it or listen to it. Now, in the event that you should have some contact inadvertently with someone that says something to you about the case, or something you think has violated these instructions, let the bailiff know. The bailiff will report it to me. I'll consult with the attorneys, and then we'll decide what, if anything, is happened that might affect your service. We may need to have you come in and ask questions of you before we make that decision, before I make that decision. One thing I want to caution you about is don't, if you have any doubts, don't ask anybody else their opinion. Just report it. And the reason I mention that is the experience I had about 30 years ago, maybe more. We had a 5-day trial, and we had 12 jurors and 3 alternates. And during lunch, one of the jurors had somebody sit down and started talking about the case. And so they came back, and they mentioned it back in the jury room, and people said, oh, you got to report that. And so they did. But because they had brought it up in the jury room with all 15 jurors there, we had to question not just that juror, but also the other 14. So we spent an entire afternoon talking to jurors, and lost an afternoon of trial time. So that's why I say, if you have any doubts, don't ask anyone else's opinion. Just err on the side of caution. Now, you've already seen we do have bench conferences time to time, and again, that's usually about matters of law. It can also be other matters such as logistics. You'll hear the static like you did this morning when we were selecting the jury, so that you don't, it doesn't come through the loudspeakers and you don't hear what we're discussing, because if we're discussing an objection and I decide that the objection is sustained, sometimes the attorneys will want to tell me what they think the answers are going to be, and then I have to decide. If I decide they're not proper, if you heard all that, that's just something more I have to tell you to disregard. So one of the purposes of that is to make sure we don't add to your burden. We try to minimize your burden. Okay, so with that, we're going to go ahead and start the trial. The opening statements will be presented first by the state, then by the defendant, and these are not evidence, as I've indicated earlier, but are simply a preview of what they believe the evidence is going to be in this case. Mr. Collins, on behalf of the state.
Thank you. May it please the court, Mr. Armitrout, ladies and gentlemen of the jury. As you already understand from voir dire, I am presenting a case today of strangulation and domestic violence. Strangulation and domestic violence that were perpetrated by this man, the defendant, Jason Krieger, against Sarah Lever. Sarah's home is on State Route 138 in Highland County. She and Jason had been in a relationship and had been living together in 2023. However, in September of 2023, things began to sour, and Sarah asked Jason to leave her home. Jason moved some of his things out, but he didn't leave. And in fact, the two continued to argue, and on September 13th of 23, things between them got considerably worse. Sarah arrived home from work that day at about 5:30 in the evening, and he was at her home. She changed into shorts in order to clean her pool and close it up for the winter. The defendant began to cuss at her, yell at her, and was following her around. This continued for a little while, but when he walked to the back of the property, she took the opportunity to run in the house and lock the doors. Now, he obviously wasn't happy about this and immediately ran to the door. While the doors were Sarah had the doors all locked, the defendant had a key to the house because he lived there. And while she's at one door, he goes to the back door, the kitchen door, throws open the door, and Sarah's standing there. He immediately grabs her by the throat and slams her up against the refrigerator. She began to swing back at him to try to get him off of her. He grabs her by the hair, throws her to the floor, where he gets on top of her and repeatedly bashes her head into the floor. He demanded that she quit doing what she was doing. He covered her mouth with his hand, covered her nose and mouth with his hand when she tried to scream for help. It stopped Sarah from breathing when he did this. She finally agreed to what he demanded, and he let her up, telling her, "You're not calling the cops." He then went around the house and started closing the curtains. As he's doing that, she took that opportunity to run from the house. She runs from the house over to the neighbor's house and asked the neighbor to call for help. Law enforcement was called and they came. Sergeant J.D. Adams of the Sheriff's Office responded to the scene, and he immediately sees Sarah. He observes her injuries. She has injuries that are obvious to her neck, head, and face. Sergeant Adams took pictures of the injuries and called for an ambulance to check Sarah out. He also placed the defendant under arrest. Sarah and the defendant lived together, and as soon as he assaulted her, bashing her head into the floor repeatedly, he committed the crime of domestic violence. When the defendant charged through the kitchen door and placed his hands around her neck, causing her to not be able to breathe, he committed the crime of strangulation. After he slammed her on the floor and covered her nose and mouth with his hand in order to keep her from yelling again, restricting her airway, he committed the crime of strangulation. These acts caused obvious physical harm to Sarah. Now, you will hear about all of this from Sarah and from Sergeant Adams, but beyond that, you will have pictures of these injuries, and they are obvious injuries. Ladies and gentlemen, a picture speaks 1,000 words. I am confident that after you hear the testimony and review these exhibits, you will come to the only conclusion that makes sense. This defendant is guilty of all counts. Thank you.
Thank you, Mr. Armitrout.
Please, Court, Ms. Collins. As the judge told you earlier, what Ms. Collins just told you is a roadmap of where she thinks the evidence will lead, and that's all my statement is right now. I told you during voir dire I thought that there would be some testimony, and there will be. Ms. Lever's going to get up on the stand and recount, at least in part, the version that Ms. Collins gave you. I believe it will be very emotional. I believe there'll be tears. I believe that there will be sobbing. I could be wrong. But I need you to hang on to that, listen to everything until the state gets their chance, until the defense gets a chance to present their case. Ms. Collins is confident that her version will be correct. I'm confident that our version will be correct. The judge gave you instructions about the defendant not taking the stand. Ladies and gentlemen, he's going to take the stand today. And this is going to be a case, in part, of he said, she said. You're going to see these pictures. State has them marked. We also have them marked. There's nothing we're afraid of in these pictures. They're not, depends on what your definition of graphic is. You all will have seen worse on television recently. They show some purported injuries. We believe that will be explained away. We think that the state is confident that there will be a finding of guilty based on the evidence. I'm confident there will be a finding of not guilty. But here's the way it works. You'll take everything you hear and everything that you receive today back there. And if you can't figure out which one of us is right, that's reasonable doubt. That's what you guys get to do today, is figure it out. Thank you.
All right, thank you. The first witness.
Sarah Lieber.
That's okay. So there's a comment there first. Feel free if you, 3 questions in, that's all you understand.
Were you sworn in the clerk's office?
Shake your head.
All right. You have a cell phone on you? All right. Now, we are broadcasting this on YouTube. Do you wish to be shown or not? I can have a camera angle where it's not showing your face. Okay. All right. Just have a seat over there then. And if you would, that is a microphone there. Pull it completely as far as we go toward the jury. There you go. Keep your voice up when you're answering questions, please. Madam Clerk.
Thank you. Please state your name for the record.
Sarah Lever,
And can you spell your first and last name for us?
Sarahleever.
Ms. Lieber, what's your home address?
It's 4923 State Route 138, Hillsborough, Ohio 45133.
What county is that in?
Highland.
Now, Ms. Lieber, do you know Jason Krieger?
Yes.
And how do you know Jason?
We dated on and off for about 2 years.
Do you see Jason Krieger in the courtroom today?
Yes.
Can you please point him out for the court?
It's in the white dress shirt.
Please let the record reflect the witnesses identify the defendant.
Sword.
Now, was he living with you in September of 2023?
Yes.
And is that at the house at 4923 State Route 138?
Yes.
How long had he been living there?
Almost 2 months.
How long were the two of you in a relationship?
Then 2 months. We were on and off before then.
Did he sleep there every night?
Yes.
Did he eat his meals there?
Yes.
Did he tell other people that he lived there?
Yes.
Did the two of you engage in a sexual relationship?
Yes.
Did he do things around the house, handyman jobs, things like that?
Yeah. Yes.
Now, at some point in September of 23, did the two of you begin having problems?
Yeah, we started fighting.
I'm sorry, I didn't hear that.
You have to speak up, please.
We started fighting.
Maybe lean in closer to that microphone. There we go.
Did you ask the defendant to leave your home?
Yes.
Do you recall, was that in September of 23?
Yes.
And did he leave when you asked him to leave?
That first night, yes.
Did he come back?
Yeah, he stayed in my driveway in his car.
I want to talk about September 13th, 2023. Do you remember that day?
Yes.
Did you go to work that day?
Yes.
What time did you arrive home from work?
It's around 5:30 in the evening.
Was the defendant at your home when you arrived there?
Yes.
Do you know where he was when you arrived home?
I don't recall, no.
What did you do when you first arrived home from work?
I went in to change my clothes.
Can I speak up?
I went in to change my clothes so that I could close my pool for the season.
And did you go outside of the pool then?
Yes.
What happened when you went outside of the pool?
He was yelling at me and accusing me of stuff. And I just kept telling him to leave.
When you say he, are you talking about the defendant?
Yes.
How long did this yelling and arguing go on?
Maybe 15 minutes.
What happened then?
He was walking towards the back of my property, so I ran in the house and locked the doors.
And then what happened?
He ran around to the front porch and tried to get in my home. He had taken my house keys.
Are all of your doors keyed with the same key?
Yes.
So, was he able to get in through the front door?
I was holding the lock, so he couldn't get in.
What happened then?
And then he went around to the side, and I did the same thing. And we did that about 2 or 3 times, back and forth. And while I was holding the side door, I guess he went around to my very back door, which I don't ever use. And it leads into my kitchen door. And I went to try to get there before he got there.
Did you get there before he got there?
At the same time, and he ripped the kitchen door out of my hand.
And what happened then?
Then he put his hands right around my neck and started shoving me backwards. And he shoved me into my fridge. And I started trying to get him off of me. And I guess I must have hit him in the face because he said, "Are you gonna hit me, bitch?" And then he grabbed me by the hair and threw me on the floor.
Once you were on the floor, where was he?
On top of me.
What was happening then?
He was beating my head in the floor with one hand, and he had his other hand on my neck.
Was he demanding that you do something?
He said, "Are you going to stop being a bitch now?"
What did you say?
And I said no.
And then what happened?
And then he started beating my head in the floor again. And I tried to scream for help. And then he covered my mouth and my nose with his hand.
Did he ask you a question again?
He said, "How about now?" And I said, "I'll do whatever you want me to do."
When he first came in, you said he put his hands around your throat. Were you able to breathe when he did that?
At first, yeah.
Were you able to breathe as he continued to hold on to your throat?
No.
When you were on the floor and he covered your face or your nose and mouth with his hand, were you able to breathe when he did that?
No.
After you told him you would do whatever he wanted, what happened?
He said, "And you're not gonna call the fucking cops either." And then he shoved me down, got off of me, and then went around to start closing my curtains and my door curtains.
What did you do?
I got up and I ran out the back of my side door as fast as I could to the road. And I had to stop because there was traffic coming. And he opened the door and said, "Can we please talk about this?" And then as soon as I could, I ran across to my neighbor's house.
And what did you tell your neighbor when you got there?
To call the police.
And did your neighbor call the police?
Yes.
Okay. So, did an officer arrive to the neighbor's house where you were?
Yeah, there's a church right next to me. He pulled into the church and walked over.
Now, just real quick, the church, do you share a parking lot with the church or a parking area with the church?
Yeah, it's my driveway, basically. The parking lot is.
So when the officer arrived, did you explain to the officer what happened?
Yes.
Now, did you feel pain as a result of this?
Yes.
Where did you feel pain?
My face, my neck, and my head.
Did paramedics come to check you out?
Yes.
Did Sergeant Adams ask to take pictures of you?
Yes.
May I approach the witness?
Yep.
I'm going to hand you what's previously been marked as State's Exhibit 1 for identification purposes. Do you recognize that?
Yes.
What is that?
It's a picture of me on my neighbor's porch after I went over there.
You have to make sure
Sorry.
you talk about this, okay? It's a picture of you where?
Sitting on my neighbor's porch.
Okay. I'm going to hand you what's previously been marked as State's Exhibit 2 for identification purposes. Do you recognize that?
Yes.
What is that?
Marks on my neck.
And State's Exhibit 3, do you recognize that?
Yes.
And what is that?
A picture of my chest.
State's Exhibit 4, do you recognize that?
Yes.
What is this?
My back of my head bleeding.
Is this gloved hand, is this from the paramedic?
Yes.
Now, the marks on your face, neck, and head in those pictures, where did those marks come from?
From Jason's hands.
Did Sergeant Adams ask you to take pictures of your neck and head pictures of your neck the next day?
Yes.
And did you do that?
Yes.
I'm going to hand you what's previously been marked as State's Exhibit 5 for identification purposes. Do you recognize this?
Yeah.
What is this?
The marks on my neck from the next day.
In State's Exhibit 6, do you recognize this?
Yes.
And what is that?
A different angle than marks on my neck from the next day.
Now, did you send those pictures, the last 2 pictures that you took, did you send those to Sergeant Adams?
Yes.
And was that on September 14th of 23?
Yes.
Our State's Exhibits 1 through 6, which are all the pictures, are those true and accurate depictions of your injuries as they appeared on September 13th and 14th of 23?
Yes.
Thank you. No further questions.
Cross?
Ms. Lever, I understand this is very difficult for you, but you understand I have to ask you some questions.
Yes.
You've known each other, dated each other for about 3 years, is that what you said?
2.
2, okay.
Your Honor, I'm sorry to interrupt, but can we get the tissues for her?
Sure.
Thank you.
Yeah, just put it right there on the bench, next to you.
And prior to September 13th, I think you indicated that things had started to get difficult, is that correct?
Yes.
And let me change gears for just a second. With you're a school bus driver, is that right?
Yes.
It's Claremont Northeastern?
Yes.
And is that basic school bus driving job? You have a morning run and an afternoon run?
Yeah.
About what time would you leave in the morning for the morning run?
From my job or from my home?
From your home, ma'am.
About 4:45 in the morning.
Okay. And then you'd finish the morning run. Typically, would you head back home?
Yes.
Okay. And what time would you get back home from the, you'd come back home, what time would you leave then for the afternoon run?
About 10 till 1.
Okay. And then you'd finish that and head home?
Yes.
And like you've already testified to, 5:30, something like that?
5:30, yeah.
Okay. I believe, isn't it true, ma'am, that you told him, since you said a week, somewhere around September 6th, you told him to get out, is that right?
Yes.
Is it your story that he took all of his stuff and put it in his car?
Yes.
Every bit of things that he had there?
Probably not everything, but most of it, yes.
Are there still items there?
No.
Isn't it true, though, ma'am, that he continued to reside inside the house for the next 6 or 7 days?
No.
So it's your testimony that he didn't spend one night in the house from September 6th through the 13th, is that correct?
That's correct.
All right. I'd like to direct your attention back to September 6th. If you can recall, isn't it true that on that evening he took your vehicle and went to a service station to gas it up for you?
After he showed up, yes.
After what?
After he showed up that night, yes.
Okay, but he took your car to gas it up for you.
Yes.
And isn't it true that on that evening you had his phone?
He left it there
Okay. Okay.
because he was missing the whole day.
And isn't it true, ma'am, that while you were gone, a call came through on the phone that you took that was from another woman? Isn't that correct?
That's correct.
And when he got home, isn't it true that you accused him of stepping out on you? Isn't that correct?
That's correct.
And isn't it also true that that's when things really soured between you two? Isn't that correct?
Yes.
Isn't it also true that prior to that week, he was living there, correct?
Yes.
And he did things around the house.
Yes.
And it was the plan for you two to have a future, is that correct?
Yes.
And when you found this out, supposedly about this other woman, it's fair to say you were devastated, correct?
Yes.
Okay. Now, ma'am, isn't it true that as part of a normal routine, you would get up in the morning, would he make you coffee to take with you?
No.
Never did?
Sometimes.
Okay. I'm guessing that there were probably arguments throughout the week because of this alleged infidelity, is that correct?
I'm sorry, can you repeat?
Isn't it true that throughout the week from September 6th up to the 13th, you guys had arguments about this alleged infidelity to you, isn't that correct?
Yes.
And isn't it true that some of them were initiated by you because of how upset you were, isn't that correct?
Correct.
Did he continue to deny that he'd stepped out on you?
Yeah.
I'd like you to direct your attention to the day before the 13th, September 12th. If you recall, did you go to work that day?
I'm not sure what day of the week was that.
It would have been the week right before this happened on a Wednesday. So
Yes.
on Thursday before this day, did you go to work?
Yes.
Okay. Anything unusual happen that morning? Anything out of the ordinary?
No,
Did he make you coffee, if you recall?
I don't recall.
Okay. Did he tell you goodbye?
I don't recall.
Okay, all right. And then you did your route and you came home on the 12th, isn't that correct?
Yes.
And isn't it true that when you got home on the 12th, he was outside working on a flower bed of some kind, is that right?
I'm not sure.
Was he doing some kind of building a flower bed or something to enhance your house?
I'm not sure on that day.
Your Honor, I'm
Okay.
going to object, ask and answer, and I'm not sure that it's relevant. It's the day before.
Well,
It will be.
I'll let it stand what's been testified to. I'll let it stand, but I think we need to move on.
And when, on the 12th, when you went inside, ma'am, did anything unusual happen then?
I'm
Your
not.
Honor, again, objection, it's the day before.
I don't recall.
Well, wait a minute.
Approach, Your Honor.
Yes.
Ma'am, isn't it true that during your break on September 12th, that you went into the bathroom and held a gun out the window and fired it off?
Objection, Your Honor.
Okay, I'll sustain that question.
Was there anything, did Jason come running into the house at all on the 12th?
Objection.
Okay, I'm going to sustain that.
So you don't, well, I'll go around it. Did you leave to go back to your afternoon shift?
The day before,
Yes.
as far as I'm aware,
Okay.
I don't recall.
And isn't it true that on the night of the 12th, that he spent the night inside the house on the couch? If you recall.
I don't recall, no.
If he didn't stay inside, did he sleep in his car?
He slept in his car a lot, yes.
Now, on the morning of the 13th, isn't it true that once again, he made you coffee before you went to work?
I don't recall.
Okay. And isn't it true, ma'am, that when you came home for your in-between shifts on the 13th, that he was outside again working on the flower box?
I'm not sure.
Okay. Isn't it true that he told you that he'd be making dinner that evening?
I'm not sure.
So I'm a little confused. When you got home in the evening, was he inside or outside? As best you can recall.
I do not remember where he was.
You don't remember, so he might have been in, he might have been out. But you went into the bedroom and changed your clothes to do some pool maintenance, is that right?
Correct.
Okay. Did you get outside to do that, or did you ever leave the house at that time?
I went outside.
Okay, did he follow you outside?
As far as I remember, yes.
Okay. And then you said he was following you around arguing with you, is that correct?
Yes.
Isn't it true, ma'am, that you had still been arguing with him about being upset over whether or not he stepped out on you?
Correct, yes.
Okay.
And he would not leave my home.
And you didn't try to do anything, like do an eviction or call law enforcement, say he was trespassing, you just asked him to leave, is that right?
Oh, yes, multiple times.
All right, so eventually when you're in the house, I think your statement is that, may I approach the witness, Your Honor?
You may.
I'll show you what we've marked as defendant's exhibit number A and ask you if you recognize that.
Yes,
Okay. You recognize the statement you filled out for Officer Adams?
correct.
The events of that day?
Yes,
Okay. He asked you to fill that out, isn't that correct?
yes.
Did you do it at your house, the neighbor's house, or the sheriff's office?
The neighbor's house.
I'm sorry?
The neighbor's house.
Okay. And the squad did come and check you out, isn't that correct?
Yes.
Did they transport you to the emergency room?
They wanted to, but they told me it was up to me.
So you didn't request to be transported, is that correct?
Correct.
Okay. Now, so according to your testimony, at some point you're in the house and he comes in and basically immediately puts his hands, something like this? I mean, like this? If you can remember. I understand things are happening
This.
really fast. So it was a shove,
No,
a push,
no.
but he put them on you. He
Both
shoved you into the
hands.
refrigerator?
In my neck, on my neck, yes.
Okay. I'm a little curious, ma'am, but in your statement, and I'm quoting here, it says, I ran in, like you've testified to, and locked the doors, and I held them, the doors, plural, with an S, shut.
Correct.
So how many doors come into your house?
3.
Okay, and you held, what, 2 doors shut, I guess?
No, we were running back and forth to the doors as he was trying to open them, and I held the lock shut.
On
One door.
One door? Mm-hmm. So when you said doors here, you shouldn't have said with an S. Is that what you're saying today?
No.
So I'm just curious, you weren't holding two doors shut like this, correct?
Not at the same time, no.
You wouldn't be able to do that in that house, isn't that correct?
Correct.
Okay. So then, after he's, according to you, pushed you into the refrigerator, is that when you started swinging at him, or was it before he grabbed you?
He grabbed me as soon as he flung open my kitchen door.
Okay, and you took swings to protect yourself?
After he pushed me into the refrigerator, yes.
Okay, both hands or left or right?
Both hands, like this.
And you made contact with his face, correct?
Apparently.
So then, at some point, he grabs your hair, pushes you to the floor, and begins banging your head into the floor.
Throws me on the floor,
Well,
yes.
let's talk about the first time here. Do you have any idea how many times your head hit the floor on the first go-round?
Probably 5 to 10.
5 to 10?
Mm-hmm.
Okay. And then he asks you, and I mean, according to you, he said, are you done being, it starts with a B and ends with an H, right?
Yes.
Okay. And your answer was no, correct?
Correct.
And then again, he starts to slam your head into the floor.
Yes.
How many times that time?
I don't know.
Was this where was he holding when he was slamming your head into the floor?
By my hair and my neck.
Okay, so like,
One hand in my hair,
okay. And like this, I guess.
one hand
Show me
around,
how- show me how.
one hand around my neck,
Okay,
one hand in my hair.
okay. So altogether, 10, 15, maybe 20 times, is that right?
Yes.
Okay. Had you consumed any alcohol that evening, ma'am, on the evening of the 13th?
Objection, relevance.
On what evening
Evening of the 13th?
overall?
You can answer that, ma'am.
No, sir.
Okay. Isn't it true, ma'am, that when you came home that day, you came in, he was standing there cooking, you slammed a bottle of beer down, and you were spoiling for a fight? Isn't that true?
I don't remember that, no.
Don't remember that? Okay. Do you remember whether he was making dinner or not?
No.
No, he wasn't, or no, you don't
I
remember?
do not remember, no.
Okay. Bottle of beer down, and you were spoiling for a fight, isn't that true?
I don't remember that, no.
Don't. I need just a moment, Your Honor. May I approach again, Your Honor?
Okay.
Back to your statement here, ma'am. Did you give that to Officer Adams before he left?
Yes.
Okay, do you recall whether or not he left before the paramedics left?
No, he was still there.
He was still there, okay. And this is a true and accurate copy of your written statement, correct?
Yes.
Okay. Sorry, Your Honor.
Redirect?
I want to talk about, when you got home, did you change your clothes?
Yes.
Did you go outside?
Yes.
Was the defendant with you outside?
Yes.
What was he doing?
Just yelling at me and accusing me of stuff.
Mr. Armitage keeps talking about the door situation. I think is essentially questioning your honesty about holding the doors shut. Explain what you were doing. Explain this.
I have a front door, I have a side door, and then I have a back door, which I don't ever use. It's like an enclosed porch. So he was going to the front door.
Who is he?
Jason.
Okay.
I would hold the deadbolt so he could not open the door. And then he would run around to the side, and I would run and hold that one so he couldn't get in.
So you weren't implying that you were doing two doors at the same time, correct?
No.
And that's not what you were implying in your statement, was it?
No, we ran back and forth to those doors.
Now, I want you to explain again, without anyone putting words into your mouth, what happened when the defendant came in the back door? What was the first thing he did?
Put both hands around my neck.
And when he shoved you into the fridge, did he take his hands off your neck, or did he just shove you like that?
Shoving me with his hands on my neck, shoving my neck back into the fridge.
What happened after he shoved you by your neck into the fridge?
That's when I started swinging my arms to try to get him off of me.
Then what happened?
Apparently I hit him because he said, "You're gonna hit me, bitch," and then grabbed me by the hair and threw me on the floor.
Why are you having trouble remembering some of the details of that day?
Objection, may we approach for a moment?
Pardon me?
May we approach for a moment? I objected.
All right, just wait a minute, please. It's overruled. You may continue.
Why are you having trouble remembering some of the smaller details of that day?
Because it's very traumatic. And it's been so long.
Ms. Lieber, did you do these injuries to your head and throat and face yourself? Did you do that to yourself?
No.
Your Honor, object. Goes beyond the scope of the cross.
Well,
So-
overruled.
I have no further questions.
All right, you may step down. What's your next witness?
Sergeant Adams.
Have you been sworn in on? Yes. All right, just have a seat there.
Please state your name for the record.
Sergeant J.D. Adams.
And are you currently employed?
Yes.
Where are you employed?
Highland County Sheriff's Office.
How long have you been employed there?
In some capacity or another since January of '02.
And what are your job responsibilities there in the sheriff's office?
I am a road patrol supervisor.
And were those your job responsibilities on September 13th of 23?
Yes.
And on September 13th of 23, were you dispatched to a call of a domestic assault or domestic situation, something of that nature?
Yes.
What was the address that you went to?
It's 4923 State Route 138.
Is that in Highland County?
Yes.
And what did you find when you arrived there?
I located when I first arrived there, I pulled into the church and located the complainant, Miss Lever, across the roadway.
Where was she at across the road? At a neighbor's?
Yes, it was the neighbor's house.
And when you approached her, can you describe what you observed about her?
She appeared to be highly distraught. There was visible injuries on her.
Was she crying?
Yes.
What did you do next?
Question her obviously as to what occurred.
And did you ask if you could take pictures of what you observed about her?
Yes.
Did you take pictures?
Yes, I did.
May I approach?
You may.
Going to hand you a series of pictures.
Certainly.
Going to hand you what's previously been marked as State's Exhibit 1 for identification purposes. Do you recognize this?
It's an overall picture of the complainant, Ms. Lever.
And State's Exhibit 2, do you recognize this?
Yes.
What is that?
Some of the visible marks that was seen on her neck.
State's Exhibit 3, do you recognize this?
Yes, it's an attempt to capture other marks that was observed on her chest.
State's Exhibit 4, do you recognize this?
Yes, that is the injury to her head that was photographed.
Now, did you ask Sarah to take pictures of her injuries the next day?
Yes.
And why did you do that?
Injuries tend to show up better the following days, and as the day progresses, bruises especially will be
Objection,
much
Your Honor.
easier to see.
Overruled.
And did Sarah take those pictures for you?
Yes.
I'm going to hand you what's previously been marked as State's Exhibit 5 for identification purposes. Do you recognize that?
Yes.
And what is that?
That's one of the pictures that was sent of her neck.
And State's Exhibit 6, do you recognize that?
Yes.
And where did you receive those two pictures?
If I recall correctly, it was through email.
From Sarah Lever?
Yes.
Now, after you took the pictures, did you contact, we're going back to September 13th.
Okay.
After you took the pictures, did you contact paramedics to check on Sarah?
Yes, Lynchburg Life Squad.
Was Jason Krieger at the residence when you arrived there?
When I first arrived there, I did not witness him, but I did see him while I was there walk from behind the church.
So I want to just briefly, can you describe the relationship between the church and Sarah's home?
So the church we're talking about is the Church of Church in Danville. So the church will sit on the left. Her residence sits on the right. It doesn't have a driveway. It shares a driveway with the church. The church parking lot is her driveway.
So, and where did you first see the defendant?
Walked from the rear of the church towards the residence where I could see him.
Okay. And do you see Jason Krieger in the courtroom today?
Yes,
Can you please point him out for the court?
the gentleman there in the white shirt.
Please let the record reflect the witnesses identify the defendant.
So ordered.
Did you take pictures of the defendant as well?
Yes.
Going to hand you what's previously been marked as State's Exhibit 7 for identification purposes. Do you recognize this?
Yes.
And what is that?
That is Mr. Krieger.
And State's Exhibit 8, do you recognize this?
That is a mark on his arm, his left arm.
Now, based on your training and experience, well, let me ask this. Have you worked other domestic assault cases?
Yes.
And based on your training and experience, is it common for both parties to have injuries or scratches?
Oh, absolutely.
Why is that?
They're typically called defensive wounds. When two people are in a conflict, naturally, there is a give and take.
Did you ask the defendant if he needed any medical attention?
Yes.
And what did he say?
Said no.
Did you ask him if he was attacked and defended himself?
I asked him if he was attacked. He said yes. I asked him if he defended himself. He said he did not he did not put hands on her.
He said he did not put hands on Ms.
Yes.
Weaver? After you took pictures of the defendant, what did you do?
Placed him under arrest. Or, no, actually, I'm trying to recall whether I placed him under arrest before or after the pictures. I cannot recall accurately. I might have detained him before I took the pictures.
Either way, so
Yes.
but both one right after the other.
Yes.
Okay, did you go into the house?
Briefly, yes.
Did you observe the kitchen area?
Yes.
And where is the main door, where is the back door in relation to the refrigerator in the kitchen?
So the quarters of that residence is, you have a back door that enters into the kitchen. The kitchen, dining room, and living room is all in an L-shaped pattern. The refrigerator would be just to the left of the side door, which would be the door facing the church, and then there's also a front door off the living room.
How far away is that door from the refrigerator?
Few steps,
A few steps?
yeah, maybe 2.
Our state's exhibits 1 through 4, which are the pictures that you identified, and 7 and 8, all pictures that you took, are those true and accurate depictions of Miss Lever? And
Say them again.
1 through 4, the 4 pictures
Yes.
that you took of Miss Lever,
Yep.
and 7 and 8, the 2 pictures you took of the defendant, are these true and accurate depictions of the 2 as they appeared on September 13th of 23?
Yes,
I have no further questions.
Ross?
Also, you were the first on scene, correct?
yes,
And when you first got there, Jason was not visible to you, is that correct?
correct.
So when you're talking to Miss Lever and getting her story, when you then saw Jason, did you immediately go over to try and talk to him?
It was rather quickly after I seen him.
Okay. And you did, when you got back to the station, filled out a report of your account of the events, is that right?
Yes,
Do you recall whether or not you put in that report that you asked him if he needed medical attention?
I don't recall.
Okay. If you can remember, about how long were you talking to Miss Lever before you saw Jason Krieger?
I can't give you an accurate answer. I can estimate, but it would be a guess at this point in time.
Yes, I don't care.
A few minutes.
Okay. And are you the one that called for the squad?
Yes,
And how long after you dispatched the squad did they arrive?
I have no idea.
Was it the Lynchburg squad?
Yes, it was.
And you were in Danville, is that right?
Yes.
Okay. And while they were administering treatment to her, did you continue to either talk to her or observe her?
Yes.
Okay. And by this time, did you see Jason?
I think I seen him before, if I recall correctly. I think I witnessed him before, spoke to him before the squad got there, and actually had him detained prior to the squad being there.
Okay, detained by you or by Officer Hughes, who I think who showed up?
By me.
Okay. So isn't it true, though, that you went over and talked to him, and without detaining him, you then went back to talk to Sarah some more?
No, he was detained before I went back to speak to the other party.
Detained in the sense, was he in cuffs and under arrest, or just trying to wait there until?
He was placed in the back of my cruiser.
Okay. Did you ever look in his vehicle or search it?
No, I did not.
Okay. And you say you did go into the house.
Yes,
And how long did you spend in there?
it was not long.
Did you see anything of anybody preparing dinner?
I don't recall. I didn't look for
Didn't
food.
look for that. Okay. And at some point in time, you provided Sarah with, this is an individual statement form, is that correct?
Yes,
And did you have a chance to look at her statement?
I believe I did.
Okay, and you took that with you back to the sheriff's office, is that correct?
Yes.
Okay. Do you remember if she filled out the statement after the squad left or before?
I believe it was both. If I recall correctly, she was filling the statement out waiting for the squad,
Okay.
and then finished it after receiving treatment.
Okay. And as far as your conversations with Jason, he said she hit him and he wasn't defending himself. Is that right?
What I asked him was, did you fight back? Did you defend yourself? And he stated that he did not place his hands on her.
Okay. And this may sound like one of Ms. Collins' CSI questions, but did you take any evidence from him, fingernails or anything, to check for any DNA possible?
No, I did not.
Okay. Do you remember how much time you spent with her after the squad left?
It was a significant amount of time. I was having to fill out the Marcy's Law paperwork, which was fairly new and fairly difficult for me to get through quickly.
I approach witness, Your Honor.
You may.
This is Marble State's Exhibit number 2. This one was taken by you at the scene, correct?
Yes.
Okay. Clearly shows, I think you call it ligature. I'm not sure what that is, but it shows a mark. Is that right?
Yes.
And then something a little fainter right there. Would you agree with that?
Yes.
Okay. And this was also taken by you, correct?
Yes.
And well, shows whatever it shows, correct? Some discoloration or something?
Yes, it was, I'll admit, not a very good picture.
And also, I noticed that there is some kind of a necklace she's wearing. Is that correct?
Yes.
You never saw her put that on the take off, did you?
No.
And this is State's Exhibit number 4. And this shows, I'm not going to say that that's a cut, but it's something that shows some blood in that area. Is that right?
It's showing a laceration that's hidden by the hair.
Okay. And where? So it's not that. Is it up in there? Is that what you're saying?
There's a laceration approximately in this area.
Okay. Can you point on your head where that is? It looks like it's more to the crown.
It's not to the crown. The picture's deceptive, but she is actually bent over this way, so it would actually be in this area, the back of the head, the top back of the head.
But you agree from this that doesn't look like what you
It's a deceptive picture.
This is State number 7, which purports to depict my client with, I know it's a shadow.
There's a shadow there, but there's a red mark to the cheek.
Okay, and did you notice the discoloration of the eye at all?
Not that I recall immediately.
Okay. And then a scrape on his arm?
Yes.
All right. Now back to case number 2.
Okay.
And this is State Exhibit number 6.
Yes.
We've got a mark and then something fainter. And now on 6, all of a sudden we've got
Absolutely.
3 marks, don't we?
On the opposite side, yes.
Okay, well, are you saying that this mark is not this mark?
No.
Or this or this?
No.
Now this is State's number 5.
Again, same.
Again.
It's
So you're saying
opposite side.
You're saying that these are here and this would be over here, is
Yes.
that right? That's kind of like puffy or swollen a little bit?
I suppose so, yeah,
I don't know what it looks like to you.
possibly.
And this is number 1.
Yes.
This just shows from a distance of a picture you took, is that right?
Yes, that's my attempt to identify who the other pictures will belong to.
Did you have to administer any first aid to her yourself?
No.
You're not, I'm sorry, I didn't hear the question.
Did he have to administer any first aid to her? Any gauze, any towels, anything like that?
I didn't, no.
You waited for the squad to get there?
Yes.
Okay. Sorry, Your Honor.
Redirect.
Thank you. Do you usually take fingernail scrapings in a domestic violence when you
No, I do not, ma'am.
when you know the identity of the assailant?
No, I do not.
Gonna first talk about State's Exhibit number 4. I guess I understood, but maybe no one else did. Explain why this picture is deceptive.
It's a close-up to show the laceration rather than an overall to show what her position of her head is. The picture is taken with her bending over so that I can stand over top of her and get a good picture of the laceration.
So, if this were,
Yes.
and where is this on her head?
If I may, I can't remember if it's left or right, but it's going to be, it's going to be in this area right here.
Okay. So, and that's why the picture seems deceptive, because we did make it clear she was bending over.
Yes.
Now, you testified before that you have pictures of the next day for the bruises and things that
Yes.
were obvious. So, State's Exhibit 2, do you recognize this?
Yes.
And what is that?
That is the day of the incident,
Okay.
pictures that I took.
State's Exhibit 5, do you recognize this?
Yes, pictures that the victim took.
Okay. Are these the same side?
No, they are not.
Okay, so the injury in State's Exhibit 2, is this that injury in State's Exhibit 5?
It would appear so, yes.
Okay. And do you find it odd, based on your training experience and the number of cases you've
No.
worked, that these bruises appear the next day?
No, absolutely not.
Okay. I have no further questions.
All right, you may step down. Any further witnesses?
I know we would move to admit our exhibits.
All right, counsel, would you approach, please? All right, ladies and gentlemen, we're going to go ahead and break for lunch. It's 5 minutes to 12. Once you be back here at 1 o'clock. During lunch hour, remember all the instructions I gave you about not discussing the matter in any way, permitting anyone to discuss it in your presence. Don't look at anything on any internet media of any sort about the case or anything. Don't look up anything or research anything on your own. And also, if any of you are together during the lunch hour, either lunch or afterwards when you're reassembled in the jury room, do not discuss the matter among yourselves. Don't form any opinions because you still haven't heard all the evidence nor the instructions of the court regarding the case. So when you return, go to the jury. We're going to remain in the courtroom to do a couple of legal things, and then we'll see you here at 1 o'clock. All right, so you're having no other witnesses, Ms. Collins?
No, we would move to admit States Exhibits 1 through 8, and we would rest.
All right, any objection?
That includes the pictures of Jason?
Yes.
1 through 8?
No objection.
Okay. All right, Mr. Armentrout?
Your Honor, we would make a motion for acquittal on Rule 29.
All right, court will overrule that motion. All right, now, you indicate you are going to call your client right after lunch?
Yes,
All right.
sir.
All right, so I'll need to put in the instruction about the defendant testifying in the jury instructions. And then I also wanted to tell you that when I was looking at the instructions on family or household member, it's interesting the way they define it. They say living with another person, spouse, person living as a spouse or a former spouse, and it says person living as a spouse means person who's living or has lived, and then cohabitation. So there is a definition, I believe, of cohabitation. I haven't put my finger on it right yet, but I know there is one, because, so I'm going to add that at page 8 and 12. 8 is the additional finding, and 12 is the domestic violence charge. And then also, I believe, let's see here, just find it here real quick. 519.25 is the instruction on domestic violence, which has the definition of family and household member in it. And I believe in definition, I have item 7, item 6, the definition, and then 7, living as a spouse. And then I believe 12 is reside. I need to add that. And then 16, the cohabit. And then 17 and 18, which are part of the definition of cohabit. Consortium and sharing a family or financial responsibility. So, all right, so I'll make those changes during the lunch break. And does either council have any other corrections or additions on the jury instruction I gave you?
Yes, Your Honor.
Okay, which page?
Page 2 or 3, but there's no section in here about the defendant being in custody.
Yeah, I've got that added. I've already added it back in the...
Page 4,
Okay.
the law of count 1
Mm-hmm.
does not require serious physical harm.
No, it does. It says substantial risk of physical harm.
Keep
Oh,
reading.
yeah, okay, on page 5, okay.
Well, it's not on page 5 on ours.
Okay, it's on page 5 of mine. Okay.
Um,
You were talking about element 2?
No. Under the essential elements?
Mm-hmm.
No. Under law, count 1. The second.
Oh, there it is, I see it, yeah.
The second paragraph?
Mhm. Yeah, I see it now. I didn't see it there.
Page 7, I'm not sure.
No, wait a minute, business, sir, no, I've already made that correction, yeah. Okay, I'm sorry, go ahead.
Page 7, under attempt, I'm not sure if this is correct, it just doesn't make any sense, so I'm guessing not. A criminal attempt is when one purposely does an act or constituting a substantial step.
That's the instruction. That's
With
what
the word
definition
"or" between act and substantial step.
is when one purposely does an act. Which one are you talking about?
Does an act or
Which line?
The second line, a criminal attempt is
Is
when
one
one,
purposely does an act. Okay, there's something's been left out then, okay.
yes.
All right. Yeah, there is something missing there, all right.
It's also missing in wherever that is in, later on in the instructions.
That would be on page 11. Yeah.
On page 12, under findings, that should be count 2 in 2 places.
Yeah. Okay, that was cut and pasted. All right.
That's it.
Anything else, Mr.
No, Your Honor.
Okay, and no additional instructions requested? All right, I'll make those changes, and we'll be ready to go at 1 o'clock for your evidence. Thank you.
Please rise.
All right, we're back on record of State versus Krager. Ladies and gentlemen, during the break, we dealt with some legal matters. The state rested, court admitted 8 exhibits, and it's now time for the defense case. Remind everybody in the courtroom to turn off your cell phone before we begin. Also, it occurred to me, I didn't let you know, you've heard I've said that the proceeding is being broadcast on YouTube, but we have the cameras so that there's no pictures of the jurors, so in case you wondered about that. So I haven't said that in the past either, and we've had it for like 2 years, so I'll try to make that part of my reminders now. Okay, Mr. Armitage?
Jason Krager, Your Honor.
Right?
Okay, Jason. You want to sworn in where you feel straight when you get up there.
Mr. Krager, would you raise your right hand, please? Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I can have a seat right there. And slide that microphone all the way, have a seat, and then slide that microphone all the way toward the jury. Make sure you keep your voice up, please.
Okay.
Main choir.
Jason, state your name
Jason Russell Krager,
and what's your address?
39 Woodville Road.
Is that, you reside there with your mother?
Yes, sir.
Okay. Are you employed?
No, sir, I was.
Okay, you're not employed right
No.
now? Okay. What kind of work do you do?
I'm a pipe layer.
Pipe layer?
Yes, sir. It's
Is that,
construction.
is that different than a pipe fitter?
Yes, sir.
What does a pipe layer do?
I put in all the sewage, water mains and storm mains for brand new subdivisions that are going up.
Is that a manual labor kind of job?
Yes, sir.
Use your hands a lot to do that?
Yes, sir. Everything.
And that's like,
It's the most
the
physical
wrong
thing
person
you
here.
can try to
It's
do.
just like putting pipes together, is that right?
Yeah.
Down, where do you work usually?
Anywhere between 6 to 23 feet deep in the ground.
Okay. And is pipe lowered down to you or whatever?
Yes, sir. I was standing in a trench box, and I'm way down there, and then they take a track hoe and they lower it down with a it's called a choker. It's a metal cable. Lower it down to me.
How long have you been doing that?
For 8.5 years.
And you work with your hands a lot?
Yes, sir.
Mr. Krieger, if you would just show your hands to the jury. That's fine, thank you. Jason, you are acquainted with Sarah Lever, is that correct?
Yes, sir.
And were you in a relationship with her?
Yes, sir.
Can you give me an estimate? Year, 2 years, 3 years, if you can remember?
Close to 3 years.
Okay. How long did you reside with her?
Maybe, I don't know, 2 or 3 months.
Okay. And was that the address that we've heard testified to today in what we call Danville, Ohio?
Yes, sir.
Okay. Mr. Krager, did there become difficulties that arose between you and Ms. Lever in your relationship?
Yes, sir.
Okay. I specifically want to start with September 13th and the week before that. Had she told you to leave?
No, sir.
Never told you to leave?
No.
Okay. And you've heard the testimony where she testified that about a week before the 13th, that she found out that, or at least she thought that you were stepping out on her with another woman. Is that correct?
Yes, sir.
And she didn't tell you to leave?
No, sir.
Okay. So she's testified, and you probably knew that she was a school bus driver. Is that right?
Yes, sir.
On the week of the 13th, were you home that week?
Yes, sir, because it rained off and on, and we didn't have work.
Okay. So were you working on September 13th?
No, sir.
All right. What was the normal routine with her working to, morning bus drive and an afternoon bus drive? What would you do in the morning?
She usually got up about 5:30, 5:45, and I'd get up before she did, and made her coffee and stuff, and,
Okay. Okay. Can you describe what the relationship was like after September 6th when she accused you of this?
we wasn't very good. Like, we weren't getting along very good. She's mad at me all the time.
Okay. I want to go back to the evening of September 12th. Do you know if you stayed in the house that night?
Yes, sir, I did.
Where'd you sleep?
On the couch.
Okay. Any fights of any kind that night?
No, but she did discharge her .380 handgun. and,
Objection.
Withdraw the question, Your Honor.
Sustain, jury will disregard that.
In the morning on the 13th, did anything unusual happen other than the normal routine?
No, I just got up and made her coffee, and she went to work, and I was building a flower bed outside our home.
Did you pour the coffee into her mug or whatever?
Yeah, she had 2 of them. She always used 2 because we just didn't have one big enough for a whole pot. And
Okay. Did you say anything to her when she left on the morning of the 13th?
yeah,
What'd you say?
I said, I love you.
And you didn't go to work that day, right?
No, sir.
Okay. Did she come home, like she's testified to at 11:30, 12 o'clock, whatever it was, after the morning run was done?
Yeah,
Where were you when she came home?
I was outside our home between the porch and our house building a flower bed.
Okay. Did you say anything to her?
No, nothing out of the normal.
Okay. Do you recall if you said anything to her about making dinner that night?
No, I took it upon myself to do it just because I didn't have to work that day.
Okay. So, on September the 13th, what time did she arrive home in the late afternoon?
About 5:30, 5:45.
Okay. What were you doing when she got home? Strike that. When she got home, where were you?
I was in the kitchen.
You weren't outside?
No, sir.
Okay. What were you doing in the kitchen?
I was boiling water. I was beginning to make spaghetti.
All right. And then she came in?
Yes, sir.
All right. What happened when she came in?
When she come in, she had a beer bottle and she slammed it on the stand next to our kitchen door.
Okay.
Or side door, I guess. And
What happened after that?
I said, hey, she just kind of mumbled something and she said, F you, and then she walked right past through our dining room into our living room, and then through our living room is our bedroom.
Okay. What happened after she came out from changing her clothes in the bedroom?
She came out and I was
That's me, Judge. I'm sorry. Dragging her across the microphone.
just, the pot of water was starting to boil and I was making spaghetti, just stirring the noodles. And she walks in, because our refrigerator is behind me.
Okay.
When you're at the stove. And she opened it up, and she got a beer out, and she said, hey. And
When she said, hey, was there any kind of tone to the hey?
kind of, to me, it sounded like, it was kind of one of them, hey, I'm sorry, let's just we're starting to maybe start getting along, maybe.
All right.
And I stopped what I was doing, and I turned.
What happened after that? Go ahead.
I turned to her and said, yeah. And she was pretty aggravated and boiling mad. That's when she started punching me.
So she started punching you.
Yeah.
All right.
No. Where you?
I approach the witness, Your Honor.
Yes.
What's your remarks to defense exhibit B? That's if you recognize that.
Yeah, that's me.
All right. And when was this taken, if you know?
That day.
That day. Okay. And is this your jail mugshot?
Yes, sir.
Does that accurately depict what your eye looked like?
Yes, sir. That's actually me in jail. That's at the jail.
Okay, you didn't take that picture, right?
No, sir.
Somebody at the jail took it.
Yeah.
Is that exhibit B?
B, Your Honor. So you just testified that she started hitting you, right?
Yes, sir.
Did you strike her?
No, sir.
Did you push her into the refrigerator?
No, sir.
All right, what happened after she struck you?
She hit me about 3 or 4 times, and then the last one I put my arm up because I had a sharp pain started going through my cheek. Later I found out that she broke my tooth off.
Objection.
Yeah, you can't talk about that.
Sustain.
So, at any time after she struck you, did she then go into the bathroom?
I'm going to object to this.
He's leading, not sustaining, he's leading.
What happened after you were hit?
I told her, I said, I've had enough of this. I'm going to call the sheriff's department and they can figure it out and you can go to jail.
All right, what happened after that?
She said if anybody's going to go to jail today.
Objection.
It's,
Sustain.
You can't say what she said, okay? All right, you've heard her testify that you grabbed her and pushed her into the refrigerator.
Yes, sir.
Did you do that?
No, sir.
Did you ever put your hands on her and move her toward the refrigerator?
No, sir.
Okay. Did you throw her to the ground by her hair?
No, sir.
Did you beat her head into the floor maybe 10 times?
No, sir.
Did you ever tell her, are you done being are you done being a bitch? Did you ever say that to her?
No, sir.
Did you ever continue to beat her head into the floor?
No, sir.
All right. Did she ever leave the house?
Yes, sir. I tried. Is it okay? I told her I was calling the police and, we're going to have the sheriff deal with it. She went into the bathroom and then she come back out.
You can't say what she said now, but she went into the bathroom and came back out, right?
Yeah.
Did she show you anything?
Yeah, she held her hair up kind of like this to let me see her neck and her chest.
Okay.
And she opened up the door and she walked out and across the street to the neighbor's house.
Did you follow her?
No.
Did you run after her?
No.
Did you in any way attempt to keep her from getting across the street and calling the police?
No, sir.
Are you telling this jury that the only physical contact you had with her is when you had your arms up when she was striking you?
Yes, sir. Just my left knee.
Sorry, Alan.
Cross?
Mr. Krieger, I'm going to ask you a series of really yes or no questions. They aren't difficult questions. They're going to require a yes or no answer. Do you understand?
Yes, ma'am.
Okay. Now, this happened on September the 13th of 23, is that correct?
Yes.
And it happened at Sarah's house in Highland County, correct?
Yes.
And you were a household member, you had been living with her, is that correct?
Yes.
And she asked you to leave the home, isn't that correct?
No.
Now, you agree with me that Sarah's a pretty timid person, isn't she?
No.
Sarah has 2 children, doesn't she?
Yes.
And you were not employed on September the 13th, correct?
Yes.
You were?
Yes.
But you weren't working on September the 13th because of rain, is that your testimony?
Yes, ma'am.
But you were working on flower boxes outside?
No, it was a flower bed made out of stones.
So,
But it was
outside?
Yes, ma'am.
Okay, so you weren't working because of rain, but you were working outside on flower beds?
Yes, ma'am.
Okay. Now, and you and Sarah were arguing because she accused you of cheating on her, isn't that correct?
Yes, ma'am.
Now, your testimony today is that, well, you first said that she came in and slammed a bottle down and angrily said something, correct?
Yes.
And then a few minutes later, she came in and nicely said, hey, correct? That's what you testified to a minute ago.
Yes.
Okay. So it's your testimony that she hit you and you said you were going to call the police, correct?
About after the 4th or 5th one, yes.
So the answer is yes.
Yes.
You were going to call the... So what time did you get a hold of the cops?
I didn't have a chance to.
You didn't call the police. But she left the house, correct?
Yes.
She went across the street to the neighbors, correct?
Yes.
You have a cell phone?
Yes, by the time
Okay, so why didn't you pick up your cell phone and dial the 911 if what you're telling is the truth?
I did.
You did call 911?
Yes.
You have a record of that?
On my phone, yes, I do.
Okay. What's your phone number? I'm going to have the sheriff's office get their record.
If you'd like to have it, it is 937 954 9011.
And your statement is that you phoned the sheriff's office, you called 911
Yes.
on September the 13th.
Yes, and the 12th.
Okay. Can you go out, call up there? Now, it's your testimony that she walked into the bathroom and came back out and showed you her neck. Is that correct?
Yes.
So are you asking this jury to believe that she bloodied her own head and did that to herself?
I'm not asking them nothing. I'm just stating the truth.
Okay. Now, when Sergeant Adams got there, you were outside, is that correct?
Yes,
Did you speak with Sergeant Adams?
yes,
Did you tell Sergeant Adams any of this story about her hitting you or anything like that?
yes,
Okay. And did you tell him that the rest of this that you told today?
yes,
You did?
yes,
Do you recall Sergeant Adams testifying?
yes,
Okay. And you would agree with me that you're the only one here with a motive to be dishonest, aren't you?
no,
You're not the only one with a motive to lie?
no ma'am,
You're not the only one with something to lose here?
no ma'am,
Okay. Well, it's Sarah's house. Do we agree on that?
what about it?
That's her house, correct?
Our house,
Well, she owns it, correct?
I paid the bills in it.
She owns the home, correct? Yes or no?
No,
It's in your name?
it's in the bank's name.
Whose the loan's name in?
Who's her?
Whose name is
Her
on the
mother
loan?
co-signed for it, so it'd probably be in her name,
It's in Sarah's name?
probably her mother's name,
So it's not in your name, is that correct?
correct.
Okay. No further questions.
Redirect.
Jason, the deputy asked you, I think, if you did anything in self-defense. Is
Yes,
that
sir.
right? And all you did was hold your arms up when you were getting struck, is that right?
Objection, he's leading,
Sustained.
and this is outside
Withdraw,
of
Your
the...
Honor.
All right.
Nothing further.
All right. We step down. You have any other witnesses?
No, Your Honor.
That's Russ.
Yep,
Move
move
for
forward.
approach, please. All right, ladies and gentlemen, we're going to take a break here of hopefully no more than 5 or 10 minutes. I'm going to ask you to go back to the jury room and remain in the jury room during that break. And I apologize for the heat. Our heating and air conditioning is controlled from some remote location, I forget where. We usually don't turn on the air conditioning until first they've met. So we try to open the windows, make it a little more comfortable. If you would go back to the jury room, and then as soon as we're done, we'll call you back in.
Please rise.
Go ahead. Seat, please. All right, the defendant has rested. State when calling a rebuttal.
Yes, Your Honor, we would call a rebuttal witness as Scott Miller from the Highland County Sheriff's Office.
Have you been sworn in? Yes, sir. All right, you have a seat over there then. Make sure your phone's off if you have a cell phone. Swing that mic over in front of you, please. Thank you. What's your name, Clark?
Please state your name for the record.
Sergeant Scott Miller.
Are you employed at the Highland County Sheriff's Office?
Yes, I am.
And what part of the Sheriff's Office are you employed in?
I'm in the 911 communications.
So would that be at the dispatch?
Yes.
And as part of your job responsibilities there, do you have the ability to access calls for service?
Yes, I do.
And tell us just broadly, what is a call for service?
Call for service is anything that would require an officer, fire, EMS, or a dispatcher to respond to or make a call.
And in the last hour, have you been requested to make some searches of the program or the software out at the Sheriff's Office?
Yes, I have.
Were you requested to search some phone numbers?
Yes.
Were you also requested to search 911 records?
Yes.
Were you requested to search calls for service?
Yes, I was.
During these searches that you were requested to do, did you locate any calls for service to the address of 4923 State Route 138 on September 13th of 2023?
The only thing I could find in our call record was to 4916 State Route 138.
Would that be the neighbor?
That appears to be the neighbor. It did report that somebody had been assaulted next door.
Did you search the records for a call from a 937-944-9011?
Dispatcher Dale Swingley searched for that phone number in the CAD system prior to me searching, and he did not find a call for service. I was looking into the 911 system, and I could not find the phone number either.
What about 937-954-9088?
Not to my record, no, it did not have that one.
No further questions.
Cross.
Did you bring records and search records from 911 calls on that time they gave you on 913?
I did not bring, we are not able to print the reports off the 911 system.
Okay, just what was searched and you just testified to, would that have also included 937-393-1421?
The call for service that I searched just shows the phone number that called us that we typed in from the person that called.
Okay, when it's a call for service, is that limited to 911?
No, it is not.
So it would also include 937-393-1421?
Yes, yes.
And did you check 1421?
Yes, I did.
And there was nothing for that?
Did not see anything, no.
How far back did they go, do you know, or just that day, 913?
I just checked 913, yes.
Okay. So do they go into separate areas, like one call for services or a 911 log and then a straight, the local number 393-1421, does that go into a different area?
No, all the calls for service are all on one CAD system.
Okay. Does there have to be any amount of time where it won't log a call, like if you dial it and then instantly hit end?
On recording the call, yes. Yes, there's a time where the recorder may not get the call if we have multiple calls come in on that same line.
Okay. I think you just answered my question, but I'm a technical dinosaur. If I call a number and before it rings hit end, there wouldn't be a record on your end?
Exactly.
Nothing further on.
Redirect.
The only call for service on that day to that area, is that what you're holding in your hand?
Yes, ma'am, yes.
And what address is that?
It's showing 4916 State Route 138.
And is that the neighbor to 4923 State Route 138?
To my knowledge, yes, it is.
No further questions.
Thank you. Step down. Any further rebuttal?
No, Your Honor.
All right. Counsel, approach, please. All right, ladies and gentlemen, that completes the case. You've heard all the evidence, and now the court will instruct you on the matters of law. Now, as I indicated this morning, the court and the jury have separate functions. You decide the facts. The court provides instructions of law. And ladies and gentlemen, it's your sworn duty to accept these instructions and apply the law as it is given to you. You're not permitted to change the law or to follow your own conception of what you think the law should be. All criminal cases begin with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. A plea of not guilty is a denial of the charges, puts in issue all the essential elements of the offense or offenses. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of either one or both of the offenses that have been charged in the indictment. Reasonable doubt is present when the jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It's a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of that person's own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You'll apply the tests of truthfulness that you apply in your daily lives. These tests include appearance of each witness upon the stand, their manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest and bias, if any, together with all of the facts and circumstances surrounding the testimony. Applying these facts, you'll assign to the testimony of each witness such weight as you deem proper. Now, you're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You'll determine what testimony is worthy of belief and what testimony is not worthy of belief. Now, each witness was subject to direct examination by the party who called them and to cross-examination by the opposite party. And during cross-examination, counsel was able to inquire into some matters that did not relate directly to issues before the court. Such questions and answers are permitted for purpose of helping you determine the credibility and the weight to be given to testimony and for no other purpose. Testimony of a defendant is to be weighed by the same rules that apply to other witnesses. Now, ladies and gentlemen, the evidence is all of the testimony that was received from the witnesses and any exhibits that the court admitted into evidence during the trial. I admitted State's Exhibits 1 through 8 and Defense Exhibit B. Evidence may be either direct or may be circumstantial or it may be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which they testify, and includes, of course, exhibits admitted into evidence during the trial. Now, circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts, which you may but are not required to make from the other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. When considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. So in other words, you can't stack one inference upon another inference to reach a factual conclusion. Now, if the circumstances create inferences that are consistent with either acquittal or guilt, then the defendant must be acquitted unless the inferences in favor of guilt rise to the level of proof beyond a reasonable doubt. In the absence of a direct evidence of a person's guilt, circumstantial evidence by itself may justify finding him guilty if it is so convincing as to exclude a reasonable doubt of guilt. Now, where the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence, convinces you beyond a reasonable doubt that the defendant is guilty. Now, evidence does not include the indictment, the opening statements, or the closing arguments that you'll hear shortly. Opening statements and closing arguments, as I've indicated previously, are simply designed to assist you. They themselves are not evidence. Any statements that may have been stricken by the court or that you were told to disregard are not evidence and must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question may have been. You must not draw any inference or speculate on the truth of any suggestion that might have been included in a question that was not answered. A number of exhibits have been introduced, and testimony relating to them has been introduced and admitted in evidence. You may consider whether those exhibits are the same objects in the same condition as they were originally. You'll determine what weight, if any, each exhibit should receive in light of all the evidence. Now, you may have observed during the course of the trial the defendant is in the custody of the sheriff's office. This is not an indication of his guilt or innocence. It simply means he's not been able to post the bond that the court required during the pendency of this action. You may not consider the fact that he's in custody for any purpose. Now, the law under which the defendant is charged in count 1 is entitled strangulation and is not entitled Ohio Revised Code 2903.18b3. Now, this law states in pertinent part as follows. No person shall knowingly cause or create a substantial risk of physical harm to another by means of strangulation or suffocation. So before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about September 13, 2023 in Highland County, Ohio, the defendant did knowingly cause or create a substantial risk of physical harm to another by means of strangulation or suffocation. Now, the essential elements of the crime of strangulation are as follows: that the defendant did 1, knowingly; 2, cause or create a substantial risk of physical harm to another; 3, by means of strangulation or suffocation; and 4, that the offense occurred in Highland County on or about the date alleged in the indictment. It's not necessary that the state prove that the offense was committed on the exact day as charged in the indictment. It's sufficient to prove it took place on a date reasonably near the date claimed. Now, there's an element called venue, and that is that before you can decide whether the state of Ohio has proved beyond a reasonable doubt all the essential elements of the offense with which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held. The state must prove beyond a reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. Now, the definition of knowingly. A person acts knowingly, regardless of his purpose, when he's aware that his conduct will probably cause a certain result, where he's aware his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed in the time in the mind of the defendant an awareness of the probability that the defendant's actions will cause a certain result or be of a certain nature. A proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose, or in this case, knowledge. Where an act is a crime, a good motive or purpose is not a defense. Now, the state charges that the defendant caused physical harm to another. Cause is an essential element of the offense. Cause is an act or failure to act which, in the natural and continuous sequence, directly produces a physical harm to a person without which it would not have occurred. Defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. Defendant is responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act. Substantial risk means a strong possibility as contrasted with a remote or significant possibility that a certain result may occur or certain circumstances may exist. Physical harm to persons means any injury, illness, or other physiological impairment, regardless of its gravity or duration. Strangulation or suffocation means any act that impeded the normal breathing or circulation of the blood by applying pressure to the throat or neck or by covering the nose and mouth. If you find the state proved beyond a reasonable doubt all of the essential elements of the offense of strangulation as charged in count 1 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of strangulation as charged in count 1 of the indictment, your verdict must be not guilty according to your findings. Now, if your verdict is guilty of count 1, you will separately determine whether the offense was committed against a family or household member. If your verdict's not guilty, then you do not determine this issue. Family or household member means a spouse, person living as a spouse, or a former spouse of the offender. Person living as a spouse means a person who is living or has lived with the offender in a common law marital relationship, who otherwise is cohabitating with the offender, who otherwise has cohabitated with the offender within 5 years prior to the date of the alleged commission of the act in question. Reside means to be at a fixed place of habitation to which a person intends to return when absent. Cohabit means living together at the same residence, or if not living at the same residence, is sharing a family or financial responsibilities and consortium. Family or financial responsibilities include such things as providing shelter, food, clothing, utilities, and commingling or combining assets. Consortium means such things as mutual respect, fidelity, affection, society, cooperation, solace, aid each other, friendship, and conjugal or sexual relations. Now, count 2. The law under which the defendant is charged in count 2 is entitled domestic violence and is numbered Ohio Revised Code 2919.25A1. This law states in pertinent part as follows. No person shall knowingly cause or attempt to cause physical harm to a family or household member. The defendant is charged with domestic violence under that section. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about September 13, 2023 in Highland County, Ohio, the defendant did knowingly cause or attempt to cause physical harm to a family or household member. Now, the essential elements of the crime of domestic violence are as follows: that the defendant did 1, knowingly, 2, cause or attempt to cause physical harm to a family or household member, and 3, that it occurred in Highland County, Ohio on or about the date alleged in the indictment. Now, many of the instructions I gave you on count 1 are repeated for count 2, so I won't read them. I'll just remind you of what those terms were. The time of the offense, venue, meaning the county of commission, knowingly, how you determine that, motive, cause, natural consequences. Count 2 also covers not just causing, but attempting to cause. And so the definition of attempt for count 2 is that attempt is when one purposely does or fails to do anything which is an act or omission constituting a substantial step in a course of conduct planned to culminate in his commission of the crime. To constitute a substantial step, the conduct must be strongly corroborative of the actor's criminal purpose. Physical harm to persons, I've already defined that for you. I've also defined family or household member and all the terms that go within that definition. So all of those apply in count 2 as well. Now, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense of domestic violence as charged in count 2 of the indictment, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of domestic violence as charged in count 2 of the indictment, your verdict must be not guilty according to your findings. Now, that is the substantive law, and I'll also tell you, so to put your minds at ease, that I do have a couple corrections to make, and then once I make those corrections, these definitions will be with you in the jury room during deliberation, so that if you, I know it's kind of daunting to hear these and say, I got to remember all this stuff, so we give you the instructions so that you can refer to them. So put your minds at ease about that. All right, so with that, the attorneys will provide closing arguments. Under the law, since the state has the burden of going for proof, they have the right to go first and then also to rebut after argument by the defendant. All right, Ms. Collins, on behalf of the state.
May it please the court, Mr. Armentrout, ladies and gentlemen of the jury, I first want to thank you on behalf of the state and the Sheriff's Office and Ms. Lever for your time and attention to this matter. Our country is one of the few that uses a jury system to decide guilt, and it only works because of citizens like yourselves who take your service seriously. And so for that, I want to sincerely thank you for your service. Now, as the judge said, I have 2 opportunities to address you this afternoon, so I will be shortened to the point with this first opportunity. I told you in my opening a few hours ago that the state would prove beyond a reasonable doubt that this defendant, Jason Krieger, committed the acts of strangulation and domestic violence against Sarah Lever on September the 13th, 2023. And we've proven that today. On September 13th of 23, Sarah arrived home from work at about 5:30 to find the defendant at her home. They had been fighting. She had asked him to leave her home. He wouldn't take no for an answer. She changed into shorts to go about cleaning her pool for the winter. But the defendant wouldn't be ignored. He followed her around, yelling and cussing at her. Finally, he walked to the back of her property, and she took that chance to run into the house and lock the doors. Now, he lived there, so he also had a house key, and she testified that all the doors are keyed the same. So she held the deadbolt on the front door so that he couldn't get in. He ran to the side door. She followed him back and forth a few times. Then he goes to the back door. She doesn't get there in time, and he comes in through the back door. As soon as he comes in, he immediately grabs Sarah around the neck. and he begins choking her, pushing her up against the refrigerator, which, as Sergeant Adams testified, is just about 2 steps from the front door. It's right, or the back door. It's right there. Grabs her by the neck, pushes her up against the refrigerator while holding his hands around her neck. As soon as he did that and she struggled to breathe, he committed the crime of strangulation. That is all that is required to commit that crime. Then he throws her to the floor. She's swinging at him, and she hits him. That makes him angry. He throws her to the floor and then gets on top of her, repeatedly bashing her head into the floor. As soon as he's done that, he's committed the crime of domestic violence. When Sarah tried to yell for help, this defendant covered her nose and mouth with his hand, again, keeping her from breathing, and he didn't want her to yell for help. That's also strangulation. When he covers her nose and mouth with his hand, which affects her breathing, that's strangulation. When Sarah was able to get away from him, basically when she agreed to do whatever he wanted, he let her up. She ran out of the house and went to the neighbor's house at 4916 State Route 138. When Sergeant Adams arrived, he found Sarah there crying, shaken, with obvious injuries. Sergeant Adams immediately noticed the injuries that she suffered and took pictures of those injuries while calling for medical help for her because she was bleeding from a head wound. Finally, he placed the defendant under arrest. Now, ladies and gentlemen, this case has moved quickly because it is not difficult. This defendant committed these crimes, and he left picture-perfect proof of the crimes he committed. This defendant is guilty.
Thank you. Mr. Armstrong, on behalf of the defendant.
Ladies and gentlemen, that's the case. You now know everything that we know. You've heard it all. And if Ms. Collins is correct, and she's going to talk a lot more here in a minute, and you're going to believe my client's guilty. But if you believe our version, he's not guilty. So this part of it's pretty simple. If you believe my client's testimony, if you believe his story, case is over. Likewise, if you believe Ms. Lever's testimony, case is over. So you got he said, she said here. So somehow you're going to have to sift through all the evidence you've heard and figure out who to believe, if anybody, or all or part of it. And if you can't, that's reasonable doubt. So you sort of, and I tend to move fast, and I'm probably not going to be very organized in my thoughts, but hang with me. If you go back to September 6th, Ms. Lever testified. She found out that he was stepping out on her, or so she thought. Big argument, and that leads all the way up to the 13th. Now, I can't tell from the testimony on the 13th whether she was in and out, whether he was in or out. I only know what he has said. His story has never changed, not one bit. So he testified that when she came home on the 13th after her afternoon bus run, that he was in there cooking spaghetti. I mean, if I was in his shoes, I could make up a million stories. Not one of them would have me cooking spaghetti. What does that mean? It's just kind of quirky. Why would you say something like that? He's given his version as to what happened. Now, if we go to Ms. Lever again, Judge, do you have the examples? You're going to get these in just a minute. So I think she testified under cross-examination that first she was strangled somehow. So I thought, well, maybe, all right. She hit him. He gets mad and kind of does this, pushes her, falls back, hits her head. Never what he said. Not that that would be a defense, but it's not what he said. He's always said, I never touched her. So I have to ask myself, what else is there? By her own testimony, you know what he does for a living. You saw his hands up to 20 times. He beat her head into the floor 20 times. She agreed not to be transported. This is one of the things he's in benefits. Who had that back there? Clearly a mark. You've heard the deputy testify. on whether I agree with it or not. I know what he said, but it's feel like it's on the top of her head. Besides that, as far as the beating her head into the ground 20 times, that's what we get. Here's another one. You figure it out. I'm not sure what that shows. It's a discoloration. I guess you can say it's a strangling mark. And the other pictures which were testified to. Clearly a line here, a lighter line there. I guess this is the other side. Again, I don't know what that is. It doesn't look like it to me, but I'm not an expert. This is another view of the same one. And what I would note about that, not that it couldn't happen, there's a very fine necklace there. Still there apparently after everything she claims went on. I don't think it's a stretch at all, ladies and gentlemen. The injuries that she would have had would have to be more than that. And she admitted that she hit him. That's what he looked like. Now, there's been some testimony at the very end, under cross-examination, and I believe Ms. Collins' exact question was, did you dial 911? Yes. You've heard the officer come up and say, no record of that. But then on cross, he said if you hang up in a hurry, there wouldn't be a record of it. They checked both the 911 and the 1421. If you hang up instantly, there wouldn't be a record of it. So I don't know what Ms. Collins is going to say. If I was sitting there, I might say, look, he lied about that. You have to figure that out. That's kind of to me, a small point in what we've been doing here for most of the day. Give me just a moment. Oh, yeah. So he's beating her head into the ground. Try to do that 10 times. This guy. He apparently says, are you done being a bitch? That was a testimony. Maybe not spelled, or maybe not quite spelled out. The answer, she says, is no. All right. I'm sitting around scratching my head trying to think, if I'm catching a beating like that, if I can get out of it by saying yes, I'm going down the road and we'll come back and do this another day. No. You'll do better at the night because I cannot wrap my hands around that.
You're not object to all the things Mr. Armourtrout would do.
I'm going to sustain that, not
The,
personal opinion, but to argue what the evidence has or has not shown.
There's also no evidence that he tried to prevent her in any way from leaving. She says that she ran out when he's closing some curtains. I don't know what to make about that, but there's no evidence that he chased after her. No medical evidence. She wasn't transported. It would seem that she should be the one that's mad. I still don't know why he was mad that day, according to her testimony. He's the one that supposedly stepped out on her, and she admitted that she was mad, devastated by what had happened. There were a lot of I don't remembers from Ms. Levere's testimony. Make of that what you will. Ladies and gentlemen, the judge read you a lot of jury instructions already, and he's got a few left. They're usually a lot longer than this, and some of them are just terribly boring, and about 3 times as long as today. But the one instruction he gave you that was proof beyond a reasonable doubt, and what that means, I'll come close to it. Judge, you'll have it. But it's proof of such a character that an ordinary person would rely on it in making most important of their own decisions.
You guys today are the ordinary person. So when you leave here, whenever we're done, you might be going out to eat dinner tonight. You're trying to decide between McDonald's and Burger King. You can rely on the state's case. That's not a big deal decision. But suppose you've got something that's really important. Are you going to rely on this evidence? What if it's a sick child? Child's been sick, going to be sick its whole life. Now comes an operation. This operation is going to cure your child. The risk, it may kill your child. This isn't it, ladies and gentlemen. Thank you, Your Honor.
All right, thank you, Mr. Armstrong. Ms. Collins, on behalf of the state.
I'm going to start with something, Mr. Armitrout, probably 15 times during his closing, I can't understand how someone would act like this. I don't understand why she would do this. I don't understand. Mr. Armitrout clearly has not been someone who's been abused by their spouse or their family member.
Object, Your Honor.
Well, I'll move on. Just stand.
He can't judge what she should or should not have done. He struggles to understand how this defendant came in the back door, put his hands around her neck, and pushed her into the refrigerator at the same time, but she showed that to you. She showed you he put his hands and pushed backwards. It's 2 steps. It is not difficult to understand. I'm not sure why it's so difficult for him to understand. It doesn't make any difference what Mr. Armitrout thinks about the laceration to the head. Because what matters, as the judges told you, as you've heard, as you're going to hear, as we talked about in jury voir dire, what matters is the testimony from the witness stand. The testimony from both Sergeant Adams and from Sarah Lever is that her head was bent over, that laceration is on the back of her head, that it was bleeding, and it was bleeding because this defendant bashed her head into the floor. Period. It doesn't matter what Mr. Armitrout thinks of it. What matters is the testimony. That's what matters, not what Mr. Armitrout thinks. Now, Mr. Armitrout told you in opening and in his closing that this is a he said, she said case, but it's not. It's really not. Because in a he said, she said case, that's all you have. You have his version of events and you have her version of events. You don't have that in this case. There's evidence. And the evidence is in the form of pictures. Pictures of injuries to Miss Lever that perfectly match what she says happened. She said, he bashed my head into the floor. Guess what you have? State's Exhibit 4, evidence of a head being bashed into the floor. This isn't a he said, she said. This is proof. This is evidence that her story is true. She says, he put his arms or his hands around my throat. He choked me. He put his hand over my face. I couldn't breathe. You have evidence of that in the pictures. The pictures from that day, she's already red and bruising down on her chest. She's already got marks up on her neck. And the next day, the bruises are really showing that. She's bruised here. Evidence that, what is that from? That is because somebody has had their hands around her neck. Someone who maybe uses his hands in his work. The other side of the neck, these marks. It's not a he said, she said. He said, she said, there is nothing else. There is no evidence of anything. We have the evidence in this case. Now, as the judge has said, and as Mr. Armitrout sort of alluded to, one of your main jobs is to judge the credibility of the witnesses. And it's going to be important here because you've got to decide if you're going to believe Ms. Lever or if you're going to believe the defendant. And you judge their credibility based on the same thing you use to judge credibility of people every single day of your lives. This is not difficult. Now, Sarah was the first witness that testified, and she is in the best position to know, see, and hear what she was testifying about because she was in the situation. She is the victim. She put herself out here for everyone, put herself out here for cross-examination. She's related an event that was embarrassing to her, subjected herself to the cross. She's nothing to gain by testifying here today. She's no bias, no reason to lie. And you saw her on the stand. She's timid, head down, feet together, arms together. This was uncomfortable for her, but she did it. Then you have Sergeant Adams. Now, he's an officer who simply gathered evidence, fact witness, gathered evidence, presented that to you in a way that was easy to understand. Nothing, again, to gain or lose by testifying. He's simply doing his job. The only person that testified today that has an interest or a bias in this case, the only person that has something to gain or lose, and therefore a reason to lie, is this defendant. And we know he's not above lying. We know that for sure now. We saw it today. But we also know it from when he spoke to Sergeant Adams the very first night. He said, I didn't lay my hands on her, didn't touch her. Well, those pictures don't look like a person that hasn't been touched. But then you saw him lie today. He said under oath that he called 911 on 9/13/23. Apparently he just didn't realize how easy it is to prove or disprove that. So the only call made at that time, and you heard the testimony from the dispatcher at the sheriff's office, they checked that number, they checked another number, they ran calls for addresses, they did everything. The only call around that time that was made on September 13th that would have coincided with his story from the stand was the call to go to the neighbor's house, which we know was Sarah calling for help. That's the only call. That was the testimony. This defendant lied to you today. He sat right there and lied. Now, when you look at the elements of this crime, the state has proven each and every element beyond a reasonable doubt. And I'm going to talk about count 2 first, because when we prove count 2, count 1 falls right into place. So count 2 is domestic violence, and to prove this, the state must prove the defendant knowingly caused or attempted to cause physical harm to Sarah Lever. She's a family or household member. That this occurred on September 13th, 2023 in Highland County. And there are a few boxes in this that are easy to check. So, Highland County. There's been no real question. Everybody has agreed that this happened in Highland County. Check that box. September 13th, 2023. Again, no question. Check that box. Everybody's agreed on that. You can easily check the physical harm box. Look at page 12 of your jury instructions. It will give you the definition of physical harm. It means injury, illness, or other physiological impairment. Remember Sarah's testimony. She suffered injury. She suffered pain. You can see the injuries in the pictures. Sergeant Adams said as soon as he saw her, he saw obvious injury. Physical harm. Check that box. Now, finally, were they family or household members? A family or household member is a person who is residing with the defendant or has resided with the defendant, or living as a spouse of the defendant, or has lived as a spouse of the defendant in the past 5 years. Again, page 12 of your jury instructions, you will see that it's a person who the defendant cohabitated with. And they both agreed to that. He agreed to it. Sarah agreed to it. They were living together. She asked him to leave, but they had been living together within the past 5 years. There's no question they're family and household member. Again, use your common sense. The testimony is that he moved in within about 2 months prior. They shared household chores. He did some handyman work around the house. They engaged in a sexual relationship. They were in a relationship. They put out there that they were both living at that residence. Ladies and gentlemen, they are family or household members. The state has proven each element. We've checked every box of domestic violence. This defendant is guilty of domestic violence. Now, let's look at strangulation. This makes the strangulation charge in count 1 really easy because most of the elements in domestic violence are also in strangulation. In order to be found guilty of strangulation, the state must prove beyond a reasonable doubt that the defendant knowingly caused or created substantial risk of physical harm to Sarah Lever, who was a family or household member, and he caused the physical harm by means of strangulation and suffocation, and that this occurred in Highland County on September 13th of 23. Again, lots of boxes we can check right off the top. Highland County, September 13th, 2023. Physical harm, we've already proven that in domestic violence. You guys have the pictures, you know the injuries. Physical harm is proven. Family or household member, you've already found that from domestic violence. They live together. Not going to go through it all again. Strangulation or suffocation. So this is the new element for this charge. And the definition of strangulation and suffocation are on page 7 of your jury instructions. But basically, somebody put their hands around somebody else's throat and impeded their breathing, or put their hand over their mouth and nose and again impeded their breathing. Remember the testimony. The testimony was he put his hands around her throat and choked her, and she had trouble breathing. Then, after he threw her to the floor, put his hand over her face, again, she had trouble breathing. Ladies and gentlemen, strangulation or suffocation has been proven. Now, on your jury questionnaires, it's going to say there's an additional finding in this charge, and it's whether or not they were family or household members. And we've already proven that. We talked about that earlier. You've got to make sure that you put that they were family or household members, that Sarah was a family or a household member. And again, this defendant is guilty of strangulation. Look where the injuries are located. Look at the pictures from that day, because as Sergeant Adams told you, and look at the pictures from the next day, because as Sergeant Adams told you, these injuries are going to look worse the second day, and they do. They absolutely do. You can really see the bruising on the second day. The state has proven each and every element beyond a reasonable doubt. So beyond a reasonable doubt, and Mr. Armitrout wants you to believe that beyond a reasonable doubt is equated to you having a sick child, that you would want to know for sure that this surgery is going to save their life and not kill them. Well, I would want to know that too. But here's the problem. Reasonable doubt isn't doubt. It's not a test of something that happens remotely. It's a test of things you use in your everyday lives. That's what the jury instructions say, not this once in a million, once in a lifetime event that Mr. Armitrout brought up. That's not what... We would all want absolute proof positive if it was our child facing surgery. That's not what proof beyond a reasonable doubt is. That's proof beyond any and all possible doubt, which is not the law. It is not. What we talked about in jury voir dire this morning, there is always some possible remote doubt. That's not the law. The law is reasonable doubt, doubt based on reason and common sense, things you use in your everyday lives. Don't take my word for that. Listen to the jury instructions, read the jury instructions. That definition is what the definition is that you follow. That's what the law says, not Mr. Armitrout's version. So use it. Talk about something in your everyday lives. We all have cell phones. Say that you're going to buy a new cell phone, and you want a cell phone that takes the best pictures because it's easy to download. You can pair it with something, and the pictures just go right over to whatever you pair it with. You shop around. You gather the evidence. You figure out that the new Apple iPhone is the best phone for that. You're able to find it, and if you sign a contract for 2 years with Verizon, it's free. So of course you sign the contract with Verizon. Now there is some remote possible doubt that this is not the right cell phone for you. But reasonable doubt, doubt based on reason and common sense, the standard that you employ in your everyday lives, that doubt has been overcome, just like it has been overcome in this case. You buy the cell phone. Ladies and gentlemen, I'm asking that you go back into that jury room. You remember the testimony, you review the pictures. Remember the testimony of Sarah as she described what the defendant did to her and the pain she suffered. And then look at the pictures. Pictures of Sarah both within minutes of the brutal assault and the next day. Now, Mr. Armitrout has introduced a picture of the defendant with a bruise. And there are some pictures here that show a little scratch on his arm, I think, and a little bruise on his eye. Here's the bottom line, ladies and gentlemen. If the fact that she hit him were a defense, you would have heard about it in the jury instructions. It doesn't make any difference that she admitted, I did this trying to get him off of me. If that were a defense, you would hear about that in your jury instructions. It's not a defense. It doesn't make any difference that she tried to get away from him. Again, makes no difference. That swollen eye doesn't make any difference. If it did, you would have an instruction on it. It's not a legal defense. It's just not. I'm asking you to come to the only conclusion that makes common sense in this case. Ladies and gentlemen, if a picture is worth 1,000 words, these pictures are worth 2 words. Guilty, guilty, guilty on each count. Thank you.
All right, thank you, Ms. Collins. All right, ladies and gentlemen, you've heard the closing arguments, counsel, and again, I'll remind you that they are not evidence. I'll now instruct you on how to conduct your deliberation and prepare your verdicts once you've reached them. You must be uninfluenced by any consideration of any sympathy or prejudice. It's your duty to carefully weigh all the evidence and decide all the disputed questions of fact, to apply the instructions of the court to your findings and to render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all the evidence and use your common sense and make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so the state defendant will feel their case was fairly and impartially tried. Now, if during the course of the trial the court's done anything, or said anything, or done anything that you think is an indication of my view of the facts or the case in general, you're to disregard that. It was not my intent. The court does not have the right to interfere with the province of the jury by indicating a preference, and nothing that I said was designed to do that. Now, your initial conduct upon commencing deliberations is a matter of great importance. It is not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide that you may be, or you are, wrong. Consult with one another, considering each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgments. You must each decide the case for yourself, and you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you find later that it is wrong. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinions of the other jurors. And when you go to the jury room, your first function will be to select one of your number as a foreperson. That person you select will preside over the deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. The foreperson is to serve the purpose of helping you to conduct your deliberations in an orderly manner, give each juror an opportunity to express your opinion. One additional duty, the foreperson, is to see that the verdict forms and exhibits and the copies of the instructions are returned to the court after you've reached your verdict. Now, as I've indicated, I'll place in your possession the admitted exhibits and the verdict forms, and the foreperson will retain possession of those and return them to the courtroom after you've reached your verdict. Now, until your verdict is announced in open court, you're not to disclose the status to anyone else, the status of your deliberations or the nature of your verdict. Now, this being a criminal case, before it can be said you've reached a verdict, it is necessary for all 12, and again, I'll repeat that, all 12 of you to agree upon a verdict. Now, you will have in the jury room 2 verdict forms. And the first one is count 1. It has the case name and number, and it reads that we, the jury, having been duly impaneled and sworn, find the defendant, Jason R. Krieger, and then there's a blank space there. And underneath there's a couple of asterisks to call your attention to the point that that is where you insert your finding, either guilty or not guilty. And then it goes on to read of strangulation as he stands charged in count 1 of the indictment. And then count 2 has a domestic violence case number and the statute number, and it reads the same except guilty of count 2, or guilty or not guilty of domestic violence as stands charged in count 2 of the indictment. Again, you can write in your verdict either guilty or not guilty. Now, if you reach a verdict of guilty on count 1, then you also will need to make the additional finding. And it reads that we further find the offense was or was not committed against a family or household member. And those words are in parentheses, so you'll circle the one that applies to reflect your finding. Now, after you've reached verdicts on both counts, then each of you will sign, there are 12 lines. Each of you will sign your name on each verdict form in ink, and that is your indication that these are your verdicts, because again, all 12 of you have to sign it in order to have a verdict. Now, during the deliberations, the bailiff will be stationed right outside your door in the jury room. Again, remember to put your cell phones, if you brought them back in to the building with you, on the windowsill there because you can't have any electronic devices in the jury room during deliberations. If you need something, you have a question or you need something, write it down and knock on the door, and the bailiff will come to the door and answer it. And if it's a question, he'll bring it to me. I'll consult with the attorneys, and then I'll send you back a response in writing. Now, I can't promise you I can answer your question. I can only give you an answer. And so, for instance, if you ask me a question about the law, then I'll probably just send back and say, well, look at page whatever of the instructions. Because, again, I know it's maybe hard to find it. You're not used to dealing with this. And so if there's a question like that, I'll just make that notation. But if you ask me for something that wasn't provided during the trial in the way of evidence or testimony, I can't provide that. So if somebody has a question like, I remember one time there was a jury question about, it was in a civil case, and both parties were injured, and they wanted to know which person was removed from the scene first by ambulance. Well, I don't know, and nobody wasn't in evidence. And so if you ask a question like that about something that you want to know, did that happen or not, I can't answer that because that would be providing evidence that's not proper. You can only decide this case based on what was actually admitted in testimony and exhibits, and that will be my response if you ask for that. All right. I want to thank all of you for your patience, your cooperation. Been attentive, and this case is moving along very, very quickly. It took slightly longer than we anticipated, but nonetheless, it's moved along, and attorneys have done a good job in expediting that. And at this time, I'm going to excuse the alternates, Mr. Evanshire and Ms. Buzzkirk. Now, I would ask you to leave your cell phone number with the bailiff, and don't leave, I always want to say that, like in the movies, don't leave town. Because in the event that something happens during deliberations, we'll need to call one of you to come in. And so you're on deck, Mr. Evanshire. So if something like that happens, we would call you, so we need your number. And then if there were two people, then we'd call Ms. Buzzkirk. Now, till that happens, now we will call you and give you the word that when a verdict is reached. And until that time, you must continue to abide by all of the instructions that I gave you this morning, and not to talk about it or do any research or anything about it, because if something happens, you would come in and join the jury, replace the juror that was excused, and the deliberations would have to start from scratch. And that's happened twice in my 15 years, so that's why we do it this way. So at this time, you can go ahead and come around here and leave your number with the bailiff. Is there anything further, counsel?
No, sir.
All right, ladies and gentlemen, then if you retire to the jury room, the bailiff will bring you the verdict forms. I do need to make a couple of corrections on the instructions and the exhibits that were admitted. Thank you.
Please rise. or you want this YouTube? I will on record for the fire district.
All right, this is case number 24, miscellaneous 10, regarding transfer of funds of the Highland County North Joint Fire and Ambulance District. It's filed on January 24. The applicant's present, members of the applicant, and Ms. Collins, the prosecuting attorney representing the applicant. And let's see, as I recall, the question that the court had was that this was a general retirement fund, and we needed to know what the language of the ballot was, because under 570514, I had a question of whether it could be transferred to the general fund. And then I see you have, Ms. Collins, you did file an amended petition. I read it when it came in last week, but since we've had a busy week, I haven't read it again. So if you want to refresh my memories, what is in this?
Yes, Judge. Basically, I did some research as well as the fire district. 570514C1 allows the transfer of bond retirement funds into any fund with the approval of the Common Pleas Court if there is no sinking fund, which the fire district did not have a sinking fund. However, in speaking with the fire district, they are willing to establish a sinking fund that I believe, and we don't need permission to do that from the auditor or anything, they can just establish that. So they are establishing that, and that
You want to transfer $300,000 to that fund?
yes, and then
the balance to the general fund?
a balance to the general fund, that's correct. And the purpose of it, or the language of the levy was basically equipment, to build the building, upkeep of the building, things of that nature. So then the sinking fund money we would use for the purposes of the original levy.
And so that would leave a balance of approximately $218,609.18.
That's correct, Your Honor.
Okay. Now, you said you sent a copy to the tax commissioner for their examination approval in the last sentence. Did you decide that wasn't necessary, or did they respond yet?
They didn't respond.
Okay.
Did you get anything?
And
No.
do you know when that was sent to them?
Do you know when you sent it to the tax commissioner? Oh my gosh, it's not here.
At the same time that it was sent to you, probably.
The original? Around January 24th, Judge.
Okay. All right. Well, that's enough time for them to respond, so let's assume that they don't care. Based upon the representations and the determination of the applicant to establish a sinking fund, the court will approve the transfer of $300,000 into the sinking fund for the district for the purposes as outlined in the original levy, and the remaining balance may be transferred to the general fund for purposes of the district. All right, so I've signed that entry. All right.
I was about to ask if
You
you
want to
had
go ahead
that
and take it
entry.
downstairs and file it, and then they can take it with them and get it done.
Thank you, Judge.
All right, thank you, gentlemen.
Thank you, Your Honor.
All right, we're back on record. The jury has notified the court there's a verdict, and they're returning to the room now. Go ahead and have a seat, folks. All right, Mr. Billings, you're the foreperson. That's been a lucky seat this week. Monday, the foreman was in that seat. So, hand over the verdict to the clerk, please. Yeah, go ahead. Read the verdict, Mr. Clerk, please.
In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Jason R. Krieger, case number 23CR201, verdict, count 1, strangulation, revised code 2903.18B3. We, the jury, having been duly impaneled and sworn, find the defendant, Jason R. Krieger, guilty of strangulation as he stands charged in count 1 of the indictment. We further find that the offense was committed against a family or household member. The Court of Common Pleas, Highland County, Ohio, State of Ohio versus Jason R. Krieger, case number 23CR201, verdict, count 2, domestic violence, revised code 2925.25A. We, the jury, having been duly impaneled and sworn, find the defendant, Jason R. Krieger, guilty of domestic violence as he stands charged in count 2 of the indictment.
Thank you, Mr. Hodson. All right, ladies and gentlemen, the jury, you've heard the reading of the verdict. Is this the verdict of each of you on each of the two charges? Everybody concurs. All right. Mr. Armstrong, you wish the jury poll?
No.
All right. All right, the court then will accept the verdicts of the jury and enter findings of guilty as to both counts pursuant to the findings of the jury. Ladies and gentlemen, I want to thank you for your service. As we talked about this morning, I hear a lot of people talking about rights on TV and politics and all this and that, but people forget the duties of what we have as being lucky enough to live in this country. And so you fulfilled one of those very important duties. And I thank you on behalf of the community for doing that. As I indicated to you now, since you've were lucky enough to get called the first part of April, you're excused now for the rest of the term, so you can disregard anything. If you got plans, don't worry about it. You won't be called again. You shouldn't be called next year either. We did have one time a few years ago where there was some glitch and the computer didn't exclude those people. But if that should happen next year, just call in and remind us you served this year, because once you serve, you're excused for 2 years. All right, so you may go ahead and retire, go down to the clerk's office. Mr. Hodson will have your pay vouchers and any work excuses you may need. Again, thank you. All right, counsel, if everybody just remain, please.
Get your cell phones.
I'll be right back, Ben. All right, be seated, please. All right, the defendant has been found guilty of each of the two counts, and based upon the nature of the offenses, the court's not going to order a pre-sentence report. I will go ahead and proceed with sentencing now. See that the victim is present in the courtroom. So, Ms. Collins, on behalf of the state, anything you'd like to say?
Your Honor, I would ask the court to sentence the defendant to a term of incarceration. I think that obviously the evidence in this case spoke for itself, but more importantly is the impact that this has had on Ms. Lever. She has shown so much courage to come forward and to testify here today, and to have her credibility questioned. So many victims of domestic violence and strangulation don't do that because they don't want to go through that, and she has really shown amazing courage today. That being said, this has had such an impact on her life. She really is, and you saw her response to Mr. Armertrout's questions on the stand. Head down, hands together. This has impacted her, and it's going to take her a long time to get past this. But she's made the first right step in holding Mr. Krieger accountable. Obviously, Mr. Krieger has the right to any defense that he chooses, but to blame the defendant to blame the victim and say that he didn't put hands on her, which just flies in the face of any kind of common sense in this case. When Sergeant Adams and I were talking, he said as soon as he said that, he said, I knew, because the injuries are so obvious. She wouldn't have done this to herself, and to imply that it is ridiculous. So based on that, all of those things, I would ask the court to sentence the defendant to a term of incarceration. Thank you.
I'm sorry, does the victim wish to speak?
No, she does not, Your Honor.
All right. Mr. Armentrout?
Well, the only thing I have before me in the what I discovered was an assault, and it had some age to it, I think. There was one other offense, I'm not sure what it was by way of discovery. What's that? An assault charge, something else that was some kind of minor misdemeanor, Your Honor. So he's led a life, at least what I'm aware of, a law-abiding life. He's employable, he's got skills. Without a pre-sentence investigation, the court cannot even order probation, even the court was even thinking about. We'd ask the court to order the minimum time available under the law.
All right, Mr. Krieger, anything you'd like to say?
Thank you for your time and listening to our side of the case and everything. I really did act in self-defense. Prior from the day before that, she actually shot at me with a .38 caliber handgun. It was the second time in our relationship she did. The first time she did was 2 years prior. It was actually happening at my mother's house, and she got charged with aggravated menacing. I just cannot believe this, to be honest with you.
You can't believe what?
I kind of can't believe this, to be honest with you, because she hit me so hard and so many times that she broke the molar cleaning with my cheekbone, and I had to go get it surgically removed. I had to go get a CAT scan done with my injuries. Right before she walked in to the bathroom, she said, if anybody's going to go to jail today, and she called me MF, it's going to be you. And she walked into the bathroom, and she comes out, and she's choking herself, and she's the one who did it to herself. Nonchalantly walks across the street to the neighbor's house, and in her report, it's calm, cool, it's nice, laid out. It doesn't give you that sense of urgency. She's trying to get it done. All I was doing was cooking. She got mad at me for some girl. What it was is I left my phone there that night. I went home, I went to the gas station because her car didn't have any gas in it. While I was gone, somebody called my phone, and that's what started this whole entire thing. I just wish, and I pray and I hope that I get the minimum of what, I don't know how this goes. I had a job, I was making $25 an hour. Coming out of here, I was going to Ford Development and starting off at $42 an hour. I'm reliable, I'm dependent, I'm respectful, I'm responsible, I'm a father too. I think that's it.
Well, according to the discovery, the you have a previous conviction for an M4 disorderly conduct, which usually indicative of a reduction or a bar fight or something. And then you also have an assault conviction in 2020 in Clinton County. So this is your first experience. Now, you had a constitutional right to remain silent. It's too bad you didn't take it and use it, because you didn't do yourself any favors. You and probably your family are probably the only people in this room and watching on YouTube that would have any possibility of thinking that any one little thing that you said about this incident was true. The jury took 27 minutes. That tells you just how much BS your story was. And then, trying to say that you called 911, and yet there's no 911 call. And I don't believe for a second you did that. And you can say all you want, but they don't have the record. And if the call came through, it would have been there. And then if you were the one calling the law, you saw him come across the street, he saw you, you didn't run over across the street and say, hey, I just got socked in the jaw, and I got all these injuries. You didn't run across the street and tell him that. You waited for him to come find you.
No,
And the story you told was, I didn't lay a hand on her, and now you're telling us that you believe that she went in the bathroom and did that herself. I don't know that that's even physically possible to squeeze your own neck that hard to create that kind of bruising. But if it is possible, I don't believe that for a second that's what happened here. You're clearly a violent person. You clearly are a liar. Based on the jury thinks you lied, and their verdict, that's what it reflects, that you lied. And I see no reason to disagree with them. I think they got it 100% correct. And so it's the judgment of the court that you be and are hereby sentenced to the Correction Reception Center at Orion, Ohio, for a period of 15 months on count 1, and to a period of 6 months in Highland County Jail on count 2. By law, those are required to run concurrent, and so they will be served concurrently as required by law. Now, you were originally out on bond. I believe I revoked your bond on the 28th of March, but I believe you arrested the day before, the 27th, or was you arrested on the 28th of March and put back in jail? Do you remember? The sheriff didn't send me that information.
18 days now. Well, this time.
I'll do the calculating. Tell me what day you got arrested.
If you don't remember, you don't remember.
You were in court on the 20th, and that's when I ordered you to be held, but according to the entry, you were already in jail, and I don't have a return from the sheriff on the warrant. Actually, I think the probation department picked you up.
Oh, yeah.
That's actually right. So is that the day before they picked you up, the 27th?
I believe so.
All right. So that'd be 4 more days in March, and today is the 11th, so that's 15 days. And there was 1 day on the original arrest on November the 21st on the indictment, so that's 16 days. And let's see. I was looking here. I think he was released on an OR and a monitor, right?
The day after he was arrested.
Mini court, yeah, okay.
Can we sit, Your Honor?
All right.
Can we
Pardon?
sit? Can we sit?
Yeah, you can go ahead, sit down. All right. So, the total jail time credit then will be 15 days. Now, upon completion of the sentence, I see, Ms. Collins, I know this is a new one, maybe Mr. Armitage knows it. Has this been classified as an offense of violence for PRC purposes?
Well, it doesn't matter because it's only an F4.
Okay, yeah, so it's just 2 years.
Right.
That's right. Only offensive violence if it's a 1, 2, or 3. All right. Now, Mr. Krager, upon completion of your prison term, the adult parole authority may put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you will be supervised by a parole officer for the terms they set. And if during that period of time they determine that you have not complied, they can return you to prison to serve an additional period as a sanction of up to 1/2 of the prison term, which would be 7.5 months. for one or more violations. But if you commit a new felony under PRC, then in addition to whatever sentence the judge in the new case can impose upon you, that judge can also sentence you for committing that offense or under post-release control in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs for judgment, grant, and execution orders. And if you fail to pay court costs, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, you could do community service in this county and be given credit for each hour you worked, and an hourly rate set by the court, and each hour you worked will reduce your judgment by that amount until paid in full. Now, is there any claim for restitution?
No, Your Honor.
Okay. All right. Now, Mr. Prager, you have the right to appeal your conviction and the sentence. You have to perfect that within 30 days by filing a notice in writing with the clerk of court of this court and the Court of Appeals. You have a right to have the papers from the file and the transcript of the proceedings to pursue that appeal. If you do not have the money to hire one, the court will, you don't have money to pay for that, the court will provide that to you at no cost. You also have a right to have an attorney to represent you on that appeal. And if you do not have the money to hire an attorney, the court will again appoint one for you at no cost. You will need to fill out a new financial disclosure form if that's the case. Now, Mr. Armstrong, I don't know if there's been any discussion of appeal. I'm just assuming that it will be appealed. So if that is going to be the case, if you would file the notice of appeal and a limited appearance for that purpose, so you get that perfected within the 30 days, and then at that time I'll appoint counsel for Mr. Prager at that time. If you decide to handle the appeal, then you can discuss that with him. Then, of course, I'll appoint you to continue. All right. Anything further, counsel?
No, Your Honor.
You have the entry.
There you are.
All right. You're remanded to custody.
You want to